Okay. If and when your case is indicted, it'll be randomly assigned to one of 15 judges. So it could be me. Chances are it won't, just based on the odds. And then you and Mr. Patterson will move forward that way. But for bond purposes, we will all be working together. And I will let you know after I hear from your lawyer as well as from the prosecutor what I'm going to do about bond. Mr. Patterson, I don't think your entry of appearance, assuming you filed one, has made it into the system yet.
Probably hasn't made it.
Okay, but Mr. Bilal, you're clear. Your lawyer is the gentleman sitting next to you and not a Ms. Williams. I have the system lists a Ms. Williams as your lawyer. Okay, great. Mr. Patterson, when you're ready.
Yes. Your Honor, if it pleases the court. Your Honor, this is a case that happened on June 20th of 2023 at 765 McDaniel Street. And on that particular day, Mr. Bilal, who's 18 years old as of today, him and his friend by the name of Mr. Brown was sitting in the apartment complex, and they were just sitting on the steps. Fortunately, Your Honor, I've had the occasion to view the entire video of this shooting. And what the evidence will show, Your Honor, is that my client was sitting with his back to a rail. And you can see the metal bars, the little thin bars where you can see his back. But there's also a concrete barrier right next to those metal bars. And the evidence will show that the deceased in this case, Mr. Favors, walked up from behind up the sidewalk. It's important to note, Your Honor, that my client would not be able to see Mr. Favors coming up because of the concrete barrier, and his back was to the rail. But Mr. Favors would clearly be able to see the back of my client as he walked up. And what happened, Your Honor, the video shows just about maybe 20, 30 seconds at the most of the shooting. And it shows Mr. Favors just randomly walking up the sidewalk. And as you walk up the sidewalk, you've got to make a curve in order for my client to see Mr. Favors. He would not be able to see Mr. Favors until he literally walked up on the steps because the concrete barrier blocked everything. But Mr. Favors would clearly be able to see the back of my client because of the bars that you can see through. And as Mr. Favors walks around the barrier, within a split second behind this barrier, you could not see the actual shooting because the concrete barrier was so wide. But the moment Mr. Favors cut that corner, you see his body lean in, and all of a sudden, shooting just began at that point. You see my client then starts ducking, and then he obviously shoots Mr. Favors, and you'll see the video. He runs off the porch, he falls, he gets back up and run and come back because he dropped his phone. So he came back to get his phone. But the evidence will show that Mr. Favors literally ambushed my client, and my client obviously had to defend himself. But during this shooting, Mr. Favors also killed Mr. Brown, who was sitting on the porch with my client. So Mr. Favors actually killed Mr. Brown, and then my client returned fire, killing Mr. Favors. And Your Honor, at that point, the video basically ends after a gentleman comes back. Also at the very end, there's a gentleman that comes back and leans over the deceased, Mr. Favors. And we believe, Your Honor, that he took the weapon off of Mr. Favors and then left the scene. The state will argue, because at the previous hearing, they would argue that he simply came back and looked over the body and left. Your Honor, so we're certainly going to believe that this case will be, fortunately, there is video, and that's what makes this case a case of self-defense. But Your Honor, we believe that we just have a few witnesses. Can I start calling those witnesses, Your Honor?
Sure. These are witnesses who are going to talk about what?
Character only.
Okay.
That is correct. And Your Honor, this time we call his mother, Tashawn Bilal. I keep, Your Honor, I get it confused between Bilal and Bilal.
Not a problem. So why don't you pause right there? Because I'm happy to work this in one of two formats. If these witnesses, Mr. Patterson, are going to be speaking to Mr. Bilal's character, I'm fine for them talking right there and not being sworn, but I don't want to deprive the state of the opportunity to cross-examine them under oath if that's how they want to move forward. So as long as it's limited to character and not facts and circumstances of the situation, Mr. Bate, are you fine that we do the normal, ma'am, tell me what you want to tell me about, in this case, your son?
Yes, sir.
Okay. All right.
Yes.
So, ma'am, tell me what you want to tell me about your son.
You want to raise your right hand first?
Well, you don't even need to be sworn in.
Okay.
You're not being examined. So we're here to talk about whether your son should be on bond, with his lawyer having admitted that he has shot and killed someone as an 18-year-old. So you need to tell me why I should think that it's safe under the circumstances for your son to be in circulation.
And Your Honor, may I at least qualify who she is?
Oh, sure, you can ask any questions you want. It just doesn't need to be under oath. You
Absolutely.
can frame it how you want to frame it.
And tell the court your full name. And what's your relationship to Sean?
I'm his mom.
Okay. And tell the court what you know about his character as he was growing up until this day.
Sean is a resilient child. He has always been a smart young man. He's very intelligent. He's family oriented and loving young man. My son has never been suspended nor has been in any trouble. He graduated with honors with a 3.6 GPA and has been an honor student since kindergarten. He received over 6 offers, college offers for academics. Sean has received a full ride to the college of his choice, of which he was the only student from his high school to receive the 5 strong scholarship. So the Albany State University, in addition to the Hope Scholarship, Achieving Now, and Carver Early College Alumni, and also the 100 Black Men Scholarship. Sean has potential of being a well-rounded young man. I'm not just saying this because he's my son, but everyone that comes in contact with him says the same thing. Sean also is involved with a lot of community programs such as Stewart Center, 100 Black Men Organization, and other curriculum activities such as football. He also was in a news article for One Goal, of which he was chosen to speak about how it is to grow up in the Pittsburgh community and still maintain his grace and stay focused. Your Honor, I ask that you see that Sean's character speaks for itself and grant him a bond today.
Thank you, ma'am. I appreciate you being here. So you may have said at the beginning we were shifting and you were getting that document. Your son went to what high school?
Carver Early College.
Got it. And which of the different offers did he accept to go to college?
He is accepted Albany State University.
Albany State?
Yes.
Okay, thank you.
Your Honor, at this time we call Zonia Denham.
Excuse me. Can I give you spell her first name?
And spell your first name for the court report.
T-I-S-H-A-W-N. Thank you.
Good morning, ma'am, and I'll need you to definitely spell your first name.
It's Z with a like zebra, O-N-Y-A, like Tanya and Son.
Okay, and last name?
Denham, D as in David, E-N-H-A-M.
Thank you, ma'am.
And Ms. Denham, what is your relationship to Sean?
I'm his grandmother.
And tell the court what you know about his upbringing and his character.
Okay. I've known him for 18 years, 6 months and 14 days. Throughout our relationship, I've had opportunity to observe his character, conduct, and integrity. And I sincerely believe that he is a well-rounded, responsible young man deserving of all your fair consideration. First and foremost, I would like to highlight Sean's exceptional work ethic. From a young age, he has shown an unyielding commitment to his studies, consistency, striving for academic excellence, whether it be maintaining a superior GPA, receiving several college scholarships, which afforded him a full ride, and actively participating in extracurricular activities such as football, baseball, student council, and additional activities since elementary school. He has consistently demonstrated his dedication, discipline, and perseverance. He's also been highlighted on WSB-TV's High Five Scores. Moreover, even after Sean had to deal with finding his dad deceased at home 24 days after his 17th birthday, Sean has always exhibited strong integrity and empathy toward others. He consistently extends a helping hand to those in need, especially his family, and as a loyal friend. He demonstrates his compassion and willingness to impact his community positively. The day Sean had to turn himself in as a protector of his older brother, who was born with a disability, and his younger brother, as always, he encouraged his older brother, who would have been his college roommate, on August the 8th, and told him to go to college and knock it out the park. And to his younger brother, he told him to stay out of trouble, stay focused on good grades so he can get that money for college. He calls me honey and frequently tells me, "I've got you, honey," and he's got me. Whether volunteering or participating as a 100 Black Men member or engaging in community service projects, he embodies a strong sense of duty and commitment to giving back and showing care for others. Additionally, I have enjoyed witnessing my grandson, Sean Belair, develop excellent interpersonal skills and communication abilities. He has a natural knack for engaging in meaningful conversation, actively listening to others, and expressing his thoughts clearly and respectfully. This ability to connect with others on an emotional and intellectual level has made him a trusted confidant and friend to many. I would like to emphasize that Sean Belair has never been suspended from school and has always acted as a responsible and law-abiding individual. His sincerity and honesty are the foundation of his character, and I have seen him make conscientious choices even when faced with difficult situations. He understands the importance of accountability and has consistently committed to upholding ethical values. Also, as a descendant of Louise Watson and Atlanta Public School Teacher of the Year, a member of American Federation of Teachers, a teacher who worked in lower income areas of Atlanta and gave her time and money to those children, even making purchases from Neiman Marcus. For some, and an active fighter for integration of the Atlanta public school system. Lastly, I'm sorry. Sean Belair exhibits many characters of his great-grandmother. Almost there. Lastly, Sean Belair is a young man of incredible character, integrity, and compassion. I have witnessed firsthand his growth, development, and commitment to personal academic success. I earnestly request that you consider these qualities and his positive contributions when deciding. Should you require any additional information or wish to discuss this further, please do not hesitate to contact me with any information I can provide. Thank you for your attention and allowing me to serve as a character witness for my grandson. I also like to finally add that sometimes in life, there are obstacles to prepare us for greatness that God has in store for us. Sean, stay strong, keep your eye on the progress.
Thank you so much, Ms. Denham.
Thank you, Ms. Denham.
Your Honor, we call Melvina Hadley.
Good morning, Ms. Hadley.
Good morning.
Thank you for being here.
And Ms. Hadley, how do you know Sean?
I'm Sean's other granddad.
Okay, and tell the court what you know about his character as he was growing up to today.
Sean, from the time we brought him home from the hospital, has been one of the best children you can ever ask to have as a grandchild. Sean exhibits outstanding character as an individual of his school, his home, as well as his community. I'm not going to repeat all of the accomplishments that Sean has gone through and has received. I will not repeat all of that, but just to sum it up, I've known this child from birth. This is a child that has always been committed to doing the right thing. He has always looked after his parents. Even me, he'll call and check on me to say, how am I doing? This young man exhibits what every parent would want in a child: dedication, loyalty, academic success. And as you've heard already, all the Office of Scholarships, this young man has spent 18 years and has never been in trouble, has always been on the honors program. I cannot tell you the amount of time that I have been invited to school to witness his accomplishments. And yes, Your Honor, this young man would benefit from your consideration of granting him a bond. Thank you.
Thank you, Ms. Hadley.
Your Honor, we call Carolyn Hill.
How many folks are we calling?
It's a total of 9.
So if they're going to say he's a good guy, I've now heard real clearly from folks particularly close to him. And if we're moving further away from that close orbit.
I'll just call one more then.
Okay.
And Coach.
Ms. Hill, I'm not cutting you off. I also want to, I get it that there are a whole lot of folks who are very, very impressed with everything Mr. Bilal has done in his short 18 and a half years. And so I just want to make sure we get through what we need to get through. So for all of you who are here on his behalf, I appreciate it. It distinguishes Mr. Bilal from many of the young men that I meet in these unfortunate circumstances where there's not family and community support. So it's meaningful that you are all here, even if Mr. Patterson had lined you up to talk and now you're not going to talk. I recognize that you're all here. Coach.
And tell the court your full name.
Okay, I'm Darren Miles, the head football coach at Carver High School here in Atlanta.
Can you spell first and last?
Parrenmyles.
All right, Coach Miles.
I met Sean 4 years ago, came in as a freshman. Eager to learn. We've always had a tradition of excellence in our programs, especially amongst running backs, which is the position that he's played. And he patiently waited his turn. He didn't get a chance to really become a starter until his senior year. So what that shows to us is commitment, his resilience, attention to detail, and work ethic. When he finally got his opportunity, which was last season, he had, despite his diminutive size, led the region in rushing. Okay, and for those that follow us, he played an extremely tough region. But
Get back up.
but I was around the school through cafeteria duty, morning duty, after school duty, never had any incidents, never been called to the office or anything that he's ever done, you know, whether it's disrespecting a young lady, that's never happened. Always the first in meetings, willing to help the young freshmen that came up, and just high character as can be. And I'm hoping that with all the testimonies that you're giving, that he's given an opportunity to, you know, learn from this mistake and, you know, whatever else that we can do to make that happen.
Thank you. Your Honor, those are all our witnesses. The state may present something. If not, I just have argument.
Okay. Well, why don't you tell me what you think, and then I'll hear from Mr. Abate.
Sure. Your Honor, as the court is aware, you've heard testimony from a young man who's never been in trouble. And the court is aware that the purpose of bond is not to punish an individual, but it's just simply to ensure that he actually comes back to court. And based upon what you heard, Your Honor, it is no doubt that he's not a risk to commit a crime while out on bond. The way you determine whether somebody is a risk to commit a crime while they're out on bond is whether they've committed a crime in the past. There is no crime in my client's past history. Your Honor, also, there's no evidence that he would intimidate any witnesses, obstruct justice, and clearly with the family support and friends that he would never flee the jurisdiction. Your Honor, we, as the court is aware, Georgia favors release on bond prior to trial. It is important, Your Honor, that based upon what we heard about Mr. Bilal, is that he is a perfect candidate for bond. And I suggest, Your Honor, that based upon the seriousness of the charges, and remember, Your Honor, in terms of bond, no matter what the facts are, what the real issue is that whether he qualifies under the Ayala factors. And Your Honor, we believe that we've met the Ayala factors. And Your Honor, we would recommend these type of conditions if the court decided to grant a bond. We certainly believe that he should have a curfew. We believe that he should have either an ankle monitor or a wrist monitor, because with technology, there are now wrist monitors as well that does the same thing as ankle monitors. We believe, Your Honor, that although he is a star athlete and has a scholarship to Albany State University, due to the seriousness of this charge, I can't ask the court to allow him to go down to Albany. We believe that he should be in the Atlanta area while he's out on bond, if the court grants a bond. We also believe, Your Honor, that he should not possess any weapons of any type while out on bond. Even though he's never used drugs, we still believe the bond should say no drugs and alcohol while he's out on bond. And I don't want to insult the court's intelligence as to the amount of bond that I think the court should grant. These are very serious charges. Although we believe it's truly self-defense based upon the video, we believe a $75,000 bond total would be sufficient to ensure, even though we know that he'll be coming to court, but I just want to make sure the court recognize that this is a serious case, so the bond should be reflective of that. And Your Honor, based upon that, we would ask the court to grant a bond with those conditions and any other conditions that the court may see fit.
A couple questions. If I set a bond and your client can make it and will stay local, will he be able to enroll in any college that's local, or would the notion be to hold off on Albany State until this case is resolved? Because what I sometimes do is set a condition of release that is you're either working or you're in school. There's a curfew, but the curfew works around either a job or going to school. I certainly don't want to dictate his educational pursuits, so I wasn't sure if you had spoken with the family that there's a plan B.
Would he be able to go to school here in Atlanta if the judge grants him a bond?
So I am,
Stand, please.
Hello, Ms. Hill.
I am the program director for Five Star Scholarship Foundation, who he has a scholarship from. At this time, the scholarship is on hold. We are not sure if he will be able to take online classes in Albany, but at this time, he currently is an expected freshman. So there is an opportunity that he could do those classes online if local.
Okay, I want to be clear, I'm not making that a condition. The condition would be you're working or you're in school. I was just curious if local school was an option, because some of the school names you listed are great schools, but they would involve Mr. Bilal not being close enough to Fulton County.
He will be able to do it online. I've spoken with his advisor. They're putting it on hold until we figure what's going on. So although he's in Atlanta, he still can do classes online.
Okay, thank you, Ms. Bilal. Second question, Mr. Bilal looks like he's in kind of bad shape. Is that something that happened during the Favors-Brown encounter, or is that something that's happened since he's been in jail? And am I going to hear, because you said your client's never ever been in trouble, am I going to hear from Mr. Abate that he's been getting in lots of fights in the jail?
Not at all. He was attacked in his sleep and stabbed in the eye. He was literally asleep.
So this was an assault of which he was the victim while in custody?
That is correct.
Okay. All right. Mr. Abate, share with me what you want to share. I am particularly interested in, I just looked at the commitment paperwork, the nature of the firearm that Mr. Bilal had allegedly, according to the warrants.
Yes, Judge. Good morning.
Good morning.
The state would respectfully request you deny defense counsel's motion for bond for several reasons. I have no reason to dispute Mr. Patterson's recitation as to his client's ties to this community. And based on the number of people who have spoken to the court today, I don't believe that that is an issue. But what I would submit to the court is that the defendant is a significant threat or danger to the community and the people in it, based on the facts and circumstances from this case that occurred on June 20th of this year, Your Honor. This defendant opened fired in a breezeway of an apartment complex here in Atlanta, off of McDaniel Street, in middle of the afternoon, 5:00 p.m., shooting more than 15 rounds with a firearm that had been modified with a switch, which is in itself illegal. shooting at Mr. Favors and Mr. Brown. The person who ambushed the two victims in this case would be the defendant, not the other way around. The video surveillance footage, me and Mr. Patterson seem to have a pretty different view that we're looking at because the ambush was from the defendant, Your Honor.
So just so I followed almost all of that. Mr. Patterson went through in fairly good detail about cement and these, maybe it was handrails that Mr. Bilal was allegedly leaning against, so that if I had the Favors perspective, I could see Mr. Bilal's back. Mr. Bilal couldn't see me. As I creep up, I turn the corner. Favors open fire, killing Brown. And in defense of Brown and self, Bilal opens fire and kills Favors. That you're saying, no, Brown and Favors are minding their own business, and Bilal comes upon them with this modified illegal handgun and unloads 15 rounds, killing Favors and Brown.
Correct. Mr. Favors was shot a total of 12.
Hold on, Mr. Patterson, it's not your turn. You'll get the final word. You're the movement.
Mr. Favors was shot a total of 12 times, based on the reports that I've read and speaking with the detective. And I actually sat down with the detective yesterday after court in here, Detective Deegan, and he walked me through the video and pointed out the players and the parties. Based on speaking with Mr. Sprinkle, who did the prelim, and speaking with the detective sitting down with him yesterday, it's clear the person who was ambushing anyone was the defendant, Mr. Brown and Mr. Favors.
How do you connect this allegedly illegally modified firearm to Mr. Bilal rather than Favors or Brown? Mr. Patterson talked about people leaning over bodies and taking guns, et cetera. How does the gun for which Mr. Bilal is currently charged as an arrest warrant, how is that linked to him?
Several ways, Your Honor. What I would first indicate to the court is that the ballistics were collected from the scene. In the preliminary view of the ballistics by the APD crime lab shows that they were fired from one firearm, which would make it true or seem as if the only person that had a gun, which is what the physical evidence shows, would be the defendant. Secondly, Your Honor, after the shooting, Mr. Bilal gets on not only his Instagram, but takes over his, sounds like his older brother's Instagram, and begins to message and Instagram people. Due to the work of the detective, he was able to get a search warrant and get returns of both Mr. Favors and Mr. Bilal and his brother's Instagram. On that Instagram, the defendant is messaging his friend, asking him to go get the gun, but the switch, I think is what he says specifically, from Mac Daddy Mike's house, who is Mike Henley, who lives in the apartment complex where the shooting occurred and where the defendant fled and was found by the police later that day, minutes later.
So this isn't an arrest that occurred 3 weeks later and there's a search warrant executed and there's a gun and maybe it's connected. Mr. Bilal was taken into custody on June 20th.
No, so he actually was not taken into custody. He turned himself in several days later. I think it was June 29th. The reason for that, Your Honor, is he was taken to Grady Hospital because he had received what the state would say are ricochet fires from his own gun that struck him, and he was released from Grady a couple hours after he was admitted. He had agreed to make a statement to Detective Deegan on that day. At the day the appointment arose, he didn't show up for that appointment. He then,
Mr. Patterson, you'll get a chance, and this is a bond hearing that might not come in at trial, but it comes in a bond hearing.
And what I was about to finish that statement is he must have hired Mr. Patterson, who then called Detective Deegan and set up to have an appointment a few days later. Mr. Patterson, the defendant, and his family showed up to APD headquarters as they agreed that they would do. And when they arrived, they said they weren't going to be making a statement. Later, a day or two later, is when warrants were taken and he was contacted and he turned himself in, not hiding that from the court, not saying that he chose not to make a statement. And there's anything bad about that. He exercised his constitutional right. What I would submit to the court is that the defendant is a significant risk of intimidating witnesses, as well as the obstruction of the administration of justice, as it's clear through the Instagram messaging, he's trying to destroy and conceal and hide the evidence of this crime. There is also a ring video where you can hear all of the audio. What you hear in the audio is 15 consecutive fires from a gun like the defendant had on that day with the switch. He is seen days before in a TikTok video with the exact same firearm with a switch. So it's clear that the individual who had the firearm with the switch was the defendant. It's also clear based on the preliminary view of the ballistics evidence is that the physical evidence matches what was found on scene, which is Mr. Favors and Mr. Brown were not armed. This was a shooting because the defendant had a dispute with Mr. Favors over the last couple of weeks about an alleged stolen gun. They were having a disagreement about a gun. And on this day, the defendant decided that he was going to confront Mr. Favors by shooting him 12 times and then Mr. Brown twice, Your Honor. So based upon all of that, I would respectfully request that bond be denied at this time, and the state can assure the court that he will be indicted within the required 90 days.
Do you agree with Mr. Patterson that apart from this arrest, Mr. Bilal has no adult criminal history?
That is correct. He started big, Your Honor, with these crimes.
Okay, thank you.
There is a victim impact statement from Mr. Favors' mother, Ms. Chiquita Favors, when Your Honor deems appropriate.
No, now's the time. In the same way that I heard from witnesses on behalf of Mr. Bilal, now is the time to hear from anyone connected with Mr. Favors or Mr. Brown. Good morning, ma'am. Can you give me your name and spell it so we get it right in the record, please? All right, and you are Mr. Favors' mother? Okay, I appreciate you being here. What do you want to tell me? You probably want to tell me a lot. What we're talking about right now is whether Mr. Bilal should be considered for bond, bail, pending resolution of his charges. And so if you've got a perspective on that, it's important that I hear it.
Well, to be honest, I don't think he deserved a bond for shooting my child. My child's only 15 years old. If this is his first crime, he went be, and I don't think he deserved a bond. It's your first time being arrested and you got murdered. More than one murder charge. He doesn't deserve a bond. I'm so lost for words, I really don't know what to say. I'm so hurt and broken, angry, like.
Sure, it's all very, very recent. Your son was 15 at the time. Was he a student at Carver also? Maynard Jackson? Okay. Anything else you want to share with me?
Yes, Your Honor, and also, the other young man, I think it's Mr. Brown.
Mr. Brown.
His and Mario was friends, so Mario would never really secure.
Mario is your son?
Yes.
Got it. Okay. Thank you, ma'am. You got anyone you need to chat with back there?
Nothing further from the state, Your Honor.
Okay. Mr. Patterson, as promised, you're the movement. You get the last word that you were going to pop for a minute there.
Yeah.
I want you to share with me what you want to share, but I assume you're going to focus on this. You've watched the video. Mr. Bate's watched the video. I haven't. I think I'm going to. But help me reconcile.
Absolutely. Your Honor, first of all, I am confident that the state does not have a crime lab that says all of those shells came from the same gun.
I didn't hear him say that because, of course, we all know well that the GBI will get around to this 2024.
Yes.
It was a preliminary analysis from APD, which now has its own experts who do some of the ballistic work.
Yes.
So that's how I heard it.
But we're certain that all of those 20-something rounds will show that was not fired from the same weapon.
Okay.
Also, Your Honor, the state at the preliminary hearing, the officer speculated that my client, while pulling out his weapon, shot him own self and then accidentally shot Mr. Brown. That is absolutely not the case, Your Honor. Mr. Brown was killed by Mr. Favors. And last but not least, Your Honor, at the preliminary hearing, the officer was asked, since so many rounds, and there was also 3 different types of 9mm shells. The officer was asked, did you do a ballistics hand test on both of the deceased? His answer was no.
When you say, meaning the gunshot residue?
Gunshot residue.
Okay.
And to me, Your Honor, as a trained detective, that would be the first thing you do if you see that many shell cases with different models of 9mm shells. So, Your Honor, we believe that my client clearly would be entitled to a bond based upon the conditions that we previously talked about.
Okay.
Thank you.
Give me 1 second. I have one other question, Mr. Patterson. And I know that this is very early in the process and you have very little information from the state. And that's not because the state's violated any obligation. It's just information hasn't started flowing yet. But Mr. Abate referred to some Instagramming that your client may have been doing, suggesting a dispute about a gun or anything like that. Is that anything you want to address at this point, or that's something that's news to you and you would want to see it before you engage on that?
Your Honor, I don't have any information from the state on that, so I really can't comment on that. But we do know that the video speaks for itself, and it simply shows Mr. Favors ambushing my client. Okay. I don't know. I can't say what video that the state watched, but I clearly watched the one where he's minding his own business and Mr. Favor walks around and boom.
Okay. All right. Mr. Bilal, you have an impressive background and you've got a number of folks who have some great things to say about you. I'm struggling a little bit to reconcile that with you and the gun and the shooting. They don't align real well. But what I need to do is watch this video footage. It seems to be pretty central. It may be after I see it that I decide that really what ought to happen soon is you have an immunity hearing where a judge would determine whether what you did was clearly enough in self-defense that you ought not to be prosecuted, or instead the judge says there is some doubt about whether it was self-defense and a jury needs to decide that. Before me is solely the question of bond, and I'm going to ask Mr. Abate to get to me a copy of the video, get the same thing you're sharing with me to Mr. Patterson, so we know we're all looking at the same thing. I suspect there's only one video, but just so we're extra clear, whatever it is you make available to me, let's make sure Mr. Patterson has that as well. I will review it. If I have questions about it, there'll be questions that go to both lawyers. Because of course I only now know a little bit what Mr. Bilal looks like, but he's blocked by a monitor and he's got a Band-Aid on his head, et cetera. So I don't want to be misidentifying folks. And I've seen plenty of videos where there are 3 fuzzy objects that are 3 different people. And it may be that the video doesn't show, in my mind, what either of you is saying, and I'll need to work through that. But I think before I can make a sufficiently informed decision about bond, I need to watch the video. And I want to be clear, my decision will be driven not by the risk of flight factor. I think you've demonstrated for me sufficiently, Mr. Patterson, that Mr. Bilal, with the right conditions, is not a risk of flight because of this support group. He wouldn't want to let them down and they would hold him accountable. I heard a lot about how Mr. Bilal is about accountability. I'm actually more focused on this group, keeping Mr. Bilal accountable for showing up for court if he is out on bond. My concern is more safety of the community, and that's why I need to watch that video. The community deserves to be safe from a self-defense perspective. That's how you're framing it. The community deserves to be safe from someone with a gun with a switch on it. That's an illegal gun, jumping on someone else. And that's how the state has framed it. So I'll watch the video once I get it, and we don't need to reconvene. I can enter my bond order, whether it's denied or setting a bond. And we'll handle it that way. It sounds like the state is moving to indict it fairly expeditiously, which is good because you'll really need to get it assigned to a judge before you can get that immunity motion in front of a judge. But it sounds like that you'll make the strategy decisions for the defense. But based on your presentation to me, it sounds like that's where you'll be headed next. Is there anything else you want me to cover at this time?
Yes, you know, as the court is aware, the government always says we're going to indict somebody short. I would like to ask the court not to make a decision based upon the fact that he's asserted that.
No. That's not in referring to that one. Mr. Abate is not just any lawyer. I work with him regularly. But two, it's encouraging to hear that, but you're exactly right. What would change is that at day 91, I would have to set a bond if my decision after reviewing the video was, I don't think bond is appropriate. So that's my only point. And as I explained to you and your client when he first came out, the case remains with me until it's indicted. So if I review the video and conclude that bond isn't appropriate and we get to day 91, all you need to do is send an email saying, Judge, it's day 91. We don't have to have another hearing. Your client is entitled to a bond at that point, if it's not already indicted. But that's not influencing my decision-making. If bond is appropriate, bond is appropriate. If he makes it, he makes it. It's up to the state to move its indictment process along, however it might. Okay. Mr. Abate, anything else on behalf of the state?
No, Your Honor.
Okay. Thank you both. I'll look for that video as soon as you can get it. I don't know if it's something where it has to be on a thumb drive or it's a link. Just make sure you've confirmed that Mr. Patterson has the same thing.
Yes, Judge, I should have it to you before the end of the day.
Thank you.
Your Honor, that is all I have now. Excuse.
Yes, sir. Thank you for being here.
Let me give you my email address.
Okay.
Jackie@theflywarrior.com.
Okay, I got that.
Great.
Are we ready for Mr. Moody? Are you all here for the Moody matter, or you were here for the one we just heard? Okay. Good morning.
Your Honor, Marvin Arrington here on behalf of Mr. Moody.
Good morning, Mr. Arrington. First thing I want to say while your client's coming out here, not related to his case, I want to offer my condolences to you and your family. I was dealing with a family matter myself on the day of the celebration of life. I would have liked to have been there. I hope that you and your sibling and others are doing okay. But I heard that the ceremony was appropriately beautiful and that your remarks were moving, and I hope that you all are doing okay.
Thank you, Judge, so much. Yes, certainly sad that he's gone, but can only be happy about the life he lived and the people that he touched.
Sure, a remarkable life it was. So we have Mr. Moody in court. I need to get a couple things on the record, and then we'll talk about a motion that I just received. Ms. Rivers, are you ready to shift to Mr. Moody's case? Okay, this is 23 CP 219784, State versus Moody. Mr. Moody, good morning. I'm Judge McBurney. Your lawyer, Mr. Arrington, is on the screen. You can see right there. He's not here in court. I need to have you affirm to me on the record that you're comfortable having whatever discussion we're going to have this morning with your lawyer appearing virtually rather than sitting right by your side. Are you okay having a conversation with Mr. Arrington being on the screen?
Yes, sir.
Okay. So Mr. Moody, in theory, we were going to talk about a bond motion that Mr. Arrington filed on your behalf. You've been arrested for murder and at least a firearms offense. And unindicted murders get assigned to the elected judge who's presiding rather than going through to be heard by a magistrate. And yours was assigned to the calendar that I happen to have. I received a motion that your lawyer filed today that says that you are a living and self-aware man and that you believe I should be recused because I have deliberately violated other litigants' personal liberties in the past, and I have wantonly refused to provide due process and equal protection to all litigants. So I'm not quite sure what that means, but that's what we need to talk about first, because it may be that we don't get to bond. And if I have to recuse, well, I don't know that I have to recuse, but another judge is going to have to hear this recusal motion. And then we'll see if this gets assigned to someone else. But I just want to let you know that we may not get to bond. I'm going to turn it over to your lawyer, Mr. Arrington, and he can let me know how he wants to navigate this, and we'll go from there.
Thank you, Judge. I think Mr. Moody certainly would like to get out and would like to be heard on bond. I think that maybe one of my associates may have filed that motion. Obviously, I think, as you well know, the motion for recusal should have been based upon your previous position that you do not believe that I can represent litigants in Fulton County Court because I am also a Fulton County Commissioner. And to the extent that you don't believe I can represent anyone ever in Fulton County, and included that in an order. And so, and you have previously recused on cases, recused yourself on cases where I represent litigants. While I disagree and think that you can hear them, that has been the court's position as it regards me serving as a lawyer for 20 years and then being elected as commissioner after serving as a lawyer in 20 years in Fulton County. And so the language that was contained in that motion to recuse, what I have seen Your Honor do before is to just automatically recuse. And I believe that the previous chief judge entered an order after you entered your previous order, so that I would not have to have cases in front of you. And so I hate that we are in this place, but we are where we are. For purposes of bond today, Mr. Moody is present, his mother, his family members are present. I'm sure that they would prefer to go forward with the bond hearing today, and we could likely deal with the recusal issue later. I guess, however, if you're only going to be hearing it through indictment, then perhaps that issue will resolve itself.
Right. So two things. One, there's now a motion to recuse, so that would have to be withdrawn. But two, I thought about this when I learned that this was a case for which you were representing Mr. Moody. I am comfortable handling a preliminary matter like bond if Mr. Moody gets indicted and you stay on as his attorney. and it were assigned to me. So that's a lot of ifs. I suspect you'll stay on and you'll be his lawyer, but there's only a 1 in 15 chance that this case is assigned to me following an indictment. I would follow my customary practice based on what I think is an appropriate application of the Code of Judicial Conduct, and I would recuse. I don't see that bright line rule applying to something. I don't mean to suggest that bonds aren't substantive, but this is a preliminary or procedural matter. It's not the trial. It's not taking a guilty plea and deciding sentencing, et cetera. So I'm comfortable handling a bond hearing and managing this case until it is indicted. But that doesn't mean you're comfortable with it. And based on this motion, I've engaged in prior unethical and illegal conduct. So I'm not quite sure where that's coming from. I thought you and I had a reasoned disagreement. That's not the language you chose to use. And
Judge, I think my associate may probably file that. I did not file that and was unaware that it was filed. I think Mr. Moody would like to be heard on bond today. And I think we would withdraw that motion, or I will withdraw that motion for purposes of the bond hearing today. And as you stated, the issue would probably resolve itself as if the case ever gets indicted.
Sure. No, automatically will, because it'll either go to a different judge, or if I get it, I'll recuse, and it will very quickly be reassigned to someone else. It won't hold anyone up come indictment time. Well, if you are withdrawing the motion to recuse that was filed at 8:24 this morning, then we can move forward with bond, and you can share with me what you want to about Mr. Moody and his situation. And if his mother has something she wants to add, or anyone else, I'm happy to hear from them as well. And then I'll hear from Mr. Abate and any members of the victim's family.
Thank you. Thank you so much. Mr. Moody is 20 years old. He does not have any convictions nor any significant criminal history other than minor traffic arrests. His family, all of his family resides in the greater Atlanta area and throughout the state of Georgia. He is a graduate of high school graduate of Life Christian Academy. He currently has a record deal with Warner Records. And so he is employed, gainfully employed. He is a father. He has a 2-year-old daughter. And he is also a lifelong member of Faith Baptist Church. His mother, and other family members are on the call and certainly would like to speak. Judge, we have not, the only thing we have received in this case is an affidavit for arrest that says he was a party to a murder. We do not have any other information. I do not know when and where the preliminary hearing will be decided, but based on the information that we have now, there's not even enough information for probable cause. The state has not shared anything with us outside of the affidavit for arrest, which just says he was a party to a murder. It doesn't describe any facts, any situation. Unlike Attorney Patterson, there's no video that has been made available to us. And so we attempted to get a consent bond because there's just such a lack of any evidence that we don't understand how the state can even proceed. And I guess we would certainly want to be heard at some point in the future on the preliminary hearing calendar, if necessary, to determine if there's even, obviously if he gets a bond, he won't have that opportunity, but we just don't have any information to base anything on.
So let me say one thing in response to that. I suspect you and I will learn more from Mr. Abate about what the state thinks the facts and circumstances are surrounding your client's arrest. if there are materials that seem to be particularly significant, let's say there's a reference to a video or a statement, number one, I'll ask Mr. Bate to make that available to you. And then two, if I think that that is particularly persuasive, we'll reconvene after you had a chance to look at it and pick at it, so that you could try to rebut it or explain it. So it may be that we both, you and I, learned things today that cause me to think, I don't know that bond is a good idea, and cause you to think, I'd like a week to look into this. And of course, you'll get that week, and we don't need to wait till day 90 to revisit it if there is information that I direct the state to give to you. So you're not the first lawyer at these very, very early bond hearings who says, I really don't know why my client got arrested. And so you should tell me more about his situation in terms of what you know, and I'm happy to hear from a few folks on his behalf, and then we'll both learn a little bit from what the state has to say.
Thank you, Your Honor. I'd like to call his mother at this time to speak.
All right, let me get her. Is that Natanya? She's on mute.
Yes, it is. Good morning, Ms. Moody. Will you, Judge, would you like for me to swear her?
Yep, you're good. So no, you don't need to, Mr. Arrington, if Ms. Moody is going to limit what she has to share to character, reasons why bond is appropriate, you can ask her questions, or she's free to just narrate. That's how I typically handle it. If she's going to get into specifics about this case, then she certainly will need to be under oath, but that's typically not what the family members do.
Thank you, Your Honor. Ms. Moody, if you will, please speak to what you know about Jacoby's character and tell the judge why you believe he should receive a bond in this matter.
Sure. Good morning, Judge. First, I would like to say that we were unaware, Jacoby's family, all of us was unaware that we could actually be in person in the courtroom. So we apologize for that. And I would like to apologize to Jacoby for that if he can hear us, but we all are here on Zoom.
Sure. So I'm going to interrupt you. I'm going to interrupt you for 1 second. He can see you and he can hear you. Your son can. Okay. So in this day and age, you appearing this way is fine. As long as we can see and hear you, which we can quite clearly, then what's important is what you have to say, not that you are 10 feet away from your son as opposed to on a screen. Okay.
Thank you very much. Jacoby is actually my miracle child, Your Honor. I wasn't supposed to have any kids, and I ended up with Jacoby. Jacoby has been a sweetheart since he was a kid. He never gave me trouble in school, elementary school, middle school, or high school, never suspended, never got into fights. He was the kid that everybody wanted to be around. He was the kid that if he was picking on another kid, he would be the kid to tell you, hey, that's not cool. Jacoby has a 2-year-old daughter. All of his family is here. He goes to church. He works here. He was also baptized at the same church that he attends currently to this day. Me and his father have raised him to be the young man that he is today, which he is an astounding young man. Jacoby has never been in any trouble, school-wise, legal-wise. He doesn't have a record, Your Honor. I'm trying to figure out myself, along with Mr. Arrington, why we are here.
I'm sorry, go ahead, Judge.
No, it sounded like you got cut off. So Ms. Moody, was there anything else you wanted to share?
That's it, Your Honor.
Okay. Well, thank you for making yourself available. And again, it's not an issue that you're appearing virtually. In some ways, that makes it easier for everyone. Mr. Arrington, was there anyone else?
Yes, Your Honor. 2 more witnesses. Jackson, who is his manager, would like to let him speak to his employment. And Jackson, if you can, please state your name for the record.
Sure. Good morning. My name is Jackson, Jackson. Last name is Weingart, Weingart.
All right, thank you. And can you tell the court about Jacoby's musical career and his record deal with Warner Brothers and his employment?
Sure. I first met Jacoby about 3 or 4 years ago. I believe he was 16 or 17 years old. In that time, we've accomplished a lot together. We've gotten him a record deal. He's been able to put out 2 bodies of music, 2 full-length projects with 300 Entertainment as well as Warner Music Group. But most importantly, in that time, I think I've become somewhat of a mentor, a friend, and certainly a family member of his and the Moody's. And I've had the opportunity to work in music for 10 plus years. I run my own record label. I work with artists big and small. And for me, it's about not just determining what artists to work with, but what artists not to work with. It takes so much more than being talented today to make it. And I knew from the first song and the first time I met with Jacoby that he was obviously extremely talented, but for him, there was so much more than that. He's kind, he's loving, he's dedicated, he's determined. And all of those things are the reason why I have chosen to work with him. And he's hopefully chosen to work with me as well over the last 4 years. And he's just at the beginning of his budding career. Prior to this incident, he had plans to do a full-length album with a multi-platinum and Grammy-nominated producer named Wheezy, which we were in the middle of scheduling. But beyond that, we caught up every week about music, about life, about family. I have been able to watch him, grow from a 17-year-old kid to become a father. And every time we talk about furthering his career, it's never about, oh, I want to get a new car or I want to be rich or famous. It's never anything materialistic or egotistical. It's always about, I want to do this so I can move my family out of my old neighborhood. I want to do this so I can put money in a fund for my baby girl to go to college. I want to do this so that, Jackson, you make enough money that you can take care of your family. And I think that's why we've really bonded, because I do everything I do every day to take care of my girlfriend and my parents, who I'm still taking care of to this day. And I think that's why we really came together. And I've gotten to know him and see him grow from a young kid into a young adult now. And it's been an honor to come be a part of the ride for him. And I know that his family and providing for them is the most important thing. And I don't believe he would ever put himself in a position to ever be unable to do that.
Okay, thank you. That's a helpful perspective.
Sure.
And Mr. Arrington, you said you had one more.
Yes, Your Honor. Ms. Cummings. Ms. Cummings, you're on mute. If you could.
Am I unmuted? Am I
There you are.
unmuted?
Yes, ma'am.
Okay.
If you could please tell the judge how you know Jacoby and what you know about his character and why you think he should get a bond.
Yes, Your Honor. I am honored to provide the court with a character letter for Jacoby Moody. I have known Jacoby since birth. I am his auntie, and during his child.
Ms. Cummings, you looks like you froze on us. Judge,
Why don't we do this, Mr. Arrington? Ms. Cummings may well be able to reconnect, and we will come back to her. If you have more you want to share, you can. Otherwise, we'll pivot to Mr. Abate.
Love for his daughter
she's
is
back.
unconditional.
Ms. Cummings, we need you to start over. Looks like we lost her altogether. Judge, before we go on, if I could just ask Mr. Moody's mother, Ms. Cummings looks like she's back, but Ms. Moody, can you tell us how many other family members are present? Looks like you're on mute, Ms. Moody.
Can you hear me?
Yes.
Yes, ma'am.
What was your question?
How many other family members are present?
We have about, we have 24 here that's actually listening to everything and waiting for an outcome. But the judge said it enough, we're in person or we're doing video. So it's 24 of us that's in here right now, but Jacoby's whole family is here. I'm here, his dad here. He's been with us since birth. So, and all of his family is here.
Okay, thank you. And Ms. Cummings, you froze on us, so if you could please start over. We were not able to hear pretty much anything that you said.
Okay, no problem. Can you hear me now, sir?
Yes, ma'am.
Yes, ma'am.
Oh, okay, Your Honor, I apologize. As I stated, I'm honored to provide the court with a character letter for Jacoby Moody. I have known Jacoby since birth. I am his auntie, and during his childhood and early adult life, I have always known him to be a well-mannered and humble person. The parents of Jacoby Moody have always provided ongoing guidance and support in being involved in the community and church. They made sure he attended summer camp to keep him involved in the community and to stay away from trouble. Jacoby is one of the most respectful people that I know in this family. His heart is genuine when it comes to his family and friends. The love for his daughter is unconditional. And I have nothing but positive things to say about Jacoby. Over the years, I have witnessed Jacoby being a noticeable example for his other cousins that were getting in trouble and having mischievous behavior. Jacoby has a bright future awaiting him, and I would hate this false accusation to destroy everything his parents worked so hard for and himself worked so hard for. He wants and needs to be a productive citizen with a bright future that awaits him. If the court would please consider my reference letter on his behalf, I would appreciate it.
Thank you, Ms. Cummings.
Yes, sir.
Mr. Arrington,
Good.
anything else?
Judge, I believe that's all that we have at this time.
Okay, I will come back to you after I hear from Mr. Abate. Sir.
Thank you, Judge. The state would respectfully request the United Defense Counsel's motion for bond for several reasons. The first being the state would submit to the court that the defendant is a significant risk of committing felonies pending trial. He does have two prior pending felony cases out of Clayton County. The first being from May 4th of 2022, and the second being from 14 days later, May 18th of 2022. And in each case, he is charged with the possession of a firearm under the commission of a felony, and he is in the possession of a Schedule II substance, oxycodone. In the second case, he's also charged with tampering with evidence. Both of those cases are still pending in Clayton County, and the defendant is out on bond, or was out on bond at the time of this offense when this occurred. So I'd submit to the court that he's a risk of committing felonies pending trial if released while waiting for his case to be reached by the Superior Court, Your Honor. I'd also submit to the court that the defendant is a threat or danger to the community and the people in it based on the sheer facts and circumstances of this case. What I can tell the court is that this case is, the motive for this case is a revenge shooting, for lack of a better word, Your Honor. A couple days earlier on May 30th, this incident occurred on June 5th, but in the Lakewood area, the defendant was out near a gas station or locally off of the Lakewood Avenue, and there was a shooting in that area. Several of the defendant's friends were struck and injured, but not killed, Your Honor. What the investigators have been able to determine in speaking with witnesses is that was the motive for the killing of Mr. Tremaine Glasper in this case, Your Honor. What the investigator has been able to uncover is that in the days after the May 30th shooting, the defendant believed that he was set up by Mr. Glasper and began looking through the city to find him. There are several witnesses who indicated that the defendant called them asking where Mr. Glasper's child mother's, where she lived, and the address was given. And that was ultimately where he was killed inside of his vehicle. What the evidence would show is through LPR video footage or the cameras throughout our city captured the defendant's license plate in the area of the shooting. But before entering the apartment complex, he covered his license plate with some sort of cover that would not allow you to be able to see his tag. Upon leaving the incident location after shooting Mr. Glasper, he believed he was out of the view of the video surveillance, and he uncovered his tag. And his tag is then caught seconds after the shooting, leaving the exit of the apartment complex off of McDaniel Street, where Mr. Glasper was ultimately shot and killed in his vehicle, Your Honor. So based upon all of that, the state would respectfully request that you deny bond. As the defendant laid in wait, waiting for Mr. Glasper to come down from the apartment. And as soon as he entered his vehicle, shot him. Be perfectly candid with the court.
So that last bit that you're adding, that's from surveillance video, that's from witnesses who say that, or?
That's from witnesses, Your Honor, who have described what they saw as when Mr. Glasper got into his vehicle, what they saw the defendant get out of his Charger and run towards the vehicle where the victim was seated with two other individuals.
And it's the Charger that has, while it's at this apartment complex, according to you, the covered up tag, and then it leaves and the cover is removed from the tag.
That's correct.
You described a situation where, when your words, the defendant thought he was far enough away, he removed the cover. Is there video footage of anything like that, or it simply shows some tag readers show, I'm going to make up the color, a red Charger with a covered tag, and then just a few minutes later, there was what looks like the same red Charger going in the other direction, and the tag is uncovered? How do you, as best you understand it, how do you prove up that a tag was covered and uncovered?
So I will be candid with the court. I haven't seen the video, but what's been described to me is it's not an LPR video surveillance, photograph. It is actual video surveillance that is pointed out, that leads out from the apartment complex, and you can actually see the tag be uncovered.
Okay.
It's too far away for them to determine who's actually uncovering it, but it's a car that matches the description of the vehicle owned by Mr. Moody, Your Honor.
Okay.
I'd also bring to the court's attention that through speaking with the detectives and our local gang unit here with APD, it is, I guess, well known that the defendant is a member of the YSL record label, gang, whichever one however you want to describe it.
I don't. I try not to say those three letters because that's another judge's problem, not mine.
That was the intel that we were able to uncover as it relates to that. As I continue to gather information, provide Mr. Arrington with what I receive. It's just early, very early in the stages of the criminal prosecution. So
it is. No, it's both early but late. Mr. Moody's been in jail for a while now. And so I'm going to ask you to get to Mr. Arrington, whether it's your team expediting from getting from APD, maybe some of this video footage, whatever you think would be most compelling. If you suddenly had to make a presentation to someone that we think we have the right guy in this case, to get that to Mr. Arrington. So he's in a position to say, well, that's fascinating, but my client has a blue Charger, and this is a red. Here are photos of my client's Charger. It's blue in all these photos you've got. It's a red car. So there's clearly someone in a Charger, but not my guy's Charger.
Yes, Judge, and we're able to confirm it's his Charger, as his cell phone, the records, they move with the Charger. So wherever the Charger is seen on the LPR camera footage, his phone's.
The old cell phone records. And I don't want to say that you've got the wrong Charger. I just want to make sure Mr. Arrington has a chance to have a full-throated response to, because he's in that unenviable position of, look, my client got arrested, and that's about all I know. And it's hard to push back against what you've presented.
Yes, sir.
Okay.
Mr. Glasper's mother would like to make a statement, as well as his fiance, Ms. Glover, when.
Of course, in whatever order you want to do that. Good morning. You are?
I am the mother of the victim Tremaine Glasper. My name is LaShawna Glasper.
Ms. Glasper, thank you for being here. Can you spell your first name?
Yes, sir. LASHANA-GLASPER.
Okay. First, I'm sorry for your loss. Yes, please.
As a parent, your worst fear is to have to bury your child. And this senseless murder has been a living nightmare, knowing that my child is gone forever. I have to constantly remind my granddaughter, who is 8 and truly doesn't fully understand that no one is going to hurt her. We are constantly looking over our shoulders in fear because there's still 2 other accomplices. The home that I raised my kids is now hard for me to be there alone because of fear. We now feel vulnerable and scared at all times. Anyone in this courtroom could have been in that parking lot that night going home. My grandkids could have been in the car with their dad that night. It is our right and responsibility to do everything in our power to protect our families and fight to protect our city and community. Your Honor, I'm requesting on behalf of my family and the community to exercise the power you have to ensure that another mother doesn't have to experience this type of tragedy. I'm respectfully requesting that you do everything in your power to deny Bowman.
Ms. Glasper, how old was your son when he was killed?
He was 28.
Okay. And the 8-year-old that you mentioned, that's his daughter?
That's his daughter. He has 2, a 3-year-old and an 8-year-old.
Okay. All right. Thank you. Good morning, ma'am.
Good morning.
Could you share your name?
Yes, my name is Diamond Glover.
Okay. Diamond as in hearts, spades, and whatever the other one is, diamonds. Okay. Glover?
Yes.
All right. Thank you.
Good morning. My name is Diamond Glover. I was the fiance of Tremaine. We share a 3-year-old daughter. I'm pleading today that no bond is given to the suspect to provide my family with reassurance, safety, and comfort. The suspect in question came to my home that I share with my 4 children, one of which was Tremaine's. The situation has brought me trauma and a constant reminder of fear that the suspects or associates could return to my home. I've had to open my life, made uncomfortable changes which affected myself and my children mentally and financially. I also work from home, so it has definitely impacted me financially. Denying the blood will not bring Tremaine back, but it definitely will give my family peace of mind, knowing that the alleged suspect does not have access or opportunity to cause my family or anyone else, as well as my neighbors, to foresee any more danger. Children were shot. Children live below where Tremaine was shot. Anyone could have been hurt or harmed.
So, Ms. Glover, Mr. Glasper was shot right outside your apartment is what you're, okay.
I heard the gunshot. I can't recall how many. 2 minutes later, he was inside of the home. He walked downstairs. 2 minutes later, I came and I had to find his body.
Okay.
My friends have kids that stay on the 1st floor, directly where Tremaine was killed.
Right, at the ground level.
Yes, I had to leave my home, go from home to home because my kids, not only my 3-year-old, but my kids aged 13, 12, and 10, they are afraid. Sometimes we can't even sleep.
Okay. Thank you, ma'am. Mr. Abate, anything else?
Nothing better from the state, Your Honor.
All right. Mr. Arrington, as the movement, you get the last word. I'm going to reiterate. I know you are reacting real time to some of what you heard Mr. Abate said. And I think it's only appropriate that as he gets discovery and he needs to, through his team, expedite some of this, we get some of that to you so that you can begin to process it. But you've heard some things. It sounds like cell records, LPRs, et cetera. Tell me if there's anything more you want to add.
Thank you, Your Honor. My understanding is that 3 weeks earlier, Mr. Moody was shot, and while he was with Mr. Glasper, they were both shot at. There was a drive-by shooting, and several people were, potentially shot. And apparently my understanding, Your Honor, is that there was a hit out for Mr. Glasper. And so they were together 3 weeks earlier. They were friends. Mr. Glasper and Mr. Moody and others were both shot at 3 weeks earlier. Mr. Moody actually got shot. Apparently, Mr. Glasper also called Mr. Moody to check on him after that to see if he was okay. And so the idea that this would have been a revenge shooting against Mr. Glasper, who was also a victim of the drive-by shooting with Mr. Moody, and who called to check on Mr. Moody to see if he was okay, doesn't make any sense. It just defies logic. Certainly, we're sorry that Mr. Glasper was killed in this fashion, but, Your Honor, Mr. Moody was not the one that did it. He and Glasper, again, were both victims of a drive-by shooting 3 weeks earlier, and apparently there was a hit out on Mr. Glasper. And so we think that Mr. Moody meets the Ayala factors. We do not think he is likely to commit any other crimes. We do not think he is a flight risk. Certainly will show up for court. I am representing him on the Clayton County matters. Those matters were initially started out in misdemeanor traffic court and apparently were transferred over later, but they started out as traffic offenses in magistrate court. My law partner also represents him in his deal with Warner Brothers Records. And so we have had a long relationship with Mr. Moody as a client. The two charges in Clayton County in May, again, my understanding is they both started out in magistrate court as traffic offenses, and they may have been later upgraded, but none of those cases involve violence. And the gun that he had is registered to his mother. And so we would ask the court to grant a reasonable bond. We think that a $75,000 bond would be reasonable. Certainly would not have any objection to the court imposing an ankle or wrist monitor as the court sees fit. But given the lack of any credible information regarding Mr. Moody, and the warrant says that he was a participant. The warrant doesn't say that he did the shooting. It says he was a participant in the murder of Mr. Glasper. And so if the allegations were in fact that he was the shooter and that he got out and shot Mr. Glasper, I would suspect that would be included in the warrant, and that the warrant would not say that he was a participant. And so, again, Your Honor, we think that we have met the Ayala factors. We ask the court to grant Mr. Moody a bond. We do not believe that he will commit any crimes while out. He does not have a record of committing crimes. He's gainfully employed. And we ask the court to enter a reasonable bond in this matter.
Okay. I do want to read into the record the language from the warrant. It's sort of in between accusing him directly and the language. You're paraphrasing it pretty well, Mr. Arrington, but what the murder warrant says is that the accused, Mr. Moody, did unlawfully and with malice aforethought cause the death of another human being by taking place in the shooting death of the victim, Tremaine Glasper. Never really seen a warrant worded like that. It is not saying that he did it directly. It sounds more like he was part of a crew. So it is some peculiar wording, and that may fit in with what we heard a little bit, not as evidence, but what a couple of the witnesses said about how there were a few people maybe in or out of this charger that the state is associating with your client, Mr. Moody. So it does sound like there's more to be told about this story. Mr. Moody, at this point, I'm not going to set a bond, but I'm going to leave open the discussion. I have a couple concerns. I appreciate that the cases that you have in Clayton County started out in magistrate court, but in the span of just a few weeks, it sounds like you got picked up twice with a gun. The second time is more of a problem because you were already on bond for the first one if you got picked up for the second one. And now we've got a situation where you are alleged to have been involved with guns actually being used. I appreciate Mr. Arrington's point that the Clayton cases there's nothing violent about them. It's drugs and a gun allegedly associated with them. And Mr. Arrington's telling me it's your mom's gun and it's registered to your mom. Doesn't necessarily mean you should be rolling around with it, allegedly, but those facts are out there. I need Mr. Arrington to get more information from the state about these license plate readers and some of the video footage. And then if we need to, we can revisit this question about whether there is a bond that I could set that would assure not your appearance. I'm less worried about that. I think you wouldn't want to run away from the business opportunities you have, and even more fundamentally to what your mother was saying and your auntie, that you wouldn't run away from family obligations, in particular your daughter. I'm more worried about you being safe and the people around you being safe. By your lawyer's own admission, you got shot at a few weeks before this happened. So you're rolling in some tough spots, and I want to make sure that there's not additional blowback from everything that's happened, whether you getting shot at, Mr. Glasper being killed, et cetera. What I'm going to call the forensic evidence that the state has described. So this wouldn't be a witness saying something, but it's cameras or cell phones or this or that saying things. Those are harder to rebut because there's no bias to those things. They, in my mind, at this early juncture, sufficiently connect you to these very, very serious allegations that I want you to stay right where you are. But Mr. Arrington knows very well how to reach my staff. And if we need to reconvene to revisit this question of bond soon, we'll do that. There's another important checkpoint. At day 91, if you haven't been indicted, you are absolutely entitled to a bond. And I know Mr. Arrington will reach out to my staff saying, hey, it's day 91. And then I'm required to set a bond, even if I have some misgivings about whether you'll be safe or Ms. Glover's family will be safe. The law requires me to set a bond, and I'll do that. If between now and then your case is indicted, then you're going to be in front of a different judge, and Mr. Arrington can make all these same arguments. And more importantly, he'll be entitled to get all this discovery. So he's not sort of shooting in the dark where he's at a bit of a disadvantage. That's not his fault. It's not Mr. Arrington not being prepared. He worked with what he had, which is what he's learned from talking with you and maybe family members. So that's where I am now. Mr. Arrington, now I'm just repeating myself, but as you get information from Mr. Abate, if you think we ought to revisit this because there's new information you want to argue from, or if you're not getting information from Mr. Abate, meaning the DA's office, please reach out to Ms. Nelson about that so that I can get in the mix and say, I appreciate that discovery really hasn't started running yet, but this is a question of your client's liberty pending indictment. And I'm happy to get involved in that way. Anything else, Mr. Arrington, at this time?
Judge, Mrs. Moody would like to say something else if you are okay with that.
I'm okay with it. Ms. Moody, I just want you to know that I've made my initial ruling. So it's not going to advance a whole lot for your son to say, Judge, you made the wrong decision. I bet that's what you think because I know what you wanted me to do. I heard you clearly. And I heard Mr. Arrington very clearly. I've decided what I've decided for now, but I'm happy to revisit it. But Ms. Moody, if you want to unmute, I'm happy to hear one brief thing from you. And then I need to get to my 11 o'clock calendar. But currently, your video.
Hello?
Hey, who's this?
This is Mrs. Moody.
Okay, I can't see you.
Can you turn your video on, Mrs. Moody?
There you are. Okay.
Are
Yes,
we
ma'am.
there?
Yes, ma'am.
Yes, Your Honor. I heard everything that you were saying. I wanted to just say, I'm sorry what happened to the victim as well, but I wouldn't think that his mother would want two injustices to be done. And you were saying that you don't want to give Jacoby a bond because you want to make sure he's safe and that they are safe. However, we're the ones that's not safe. They have put out all of our information, my brother information, our address to where we live. All of Jacoby's information has been put out from the clerk office. It has the stamp on it and been sold to blogs with his social security number on it, his address. So in fact, we are the ones that are in danger because all of our information is the information that has been put out. And once again, him and the victim was friends. When the shooting happened in Lakewood, they were running together. He wouldn't call my son to check on my son if him and my son had some kind of problem with each other. And the prosecutor was just saying that my son is in a gang of YSL. Also, that is not true. He has
Ms.
done
Moody,
a
Ms.
song
Moody,
with artists.
Okay, I'm gonna stop you now. I don't think your son is in YSL just because he is a recording artist who may be under the YSL label. I appreciate what Mr. Abate said, but I want to promise you, my decision wasn't driven by the fact that your son is a potentially successful musical performer who might have some connection with that record label. That's not it at all. I don't want us to relitigate this, but I do want to say this to everyone in the room. It is very important that the Glasper group go in the Glasper direction and not get the Moody's involved with this at all. If there's something you're concerned about, you work through victim witness support, you work through the prosecutor. And I'm going to ask Mr. Arrington to let me know so that I can let the prosecutor know if there are concerns beyond what Ms. Moody has just shared, because what this cannot become is back and forth, back and forth. It may well be that Mr. Moody, the Moody sitting right in here, and Mr. Glasper were at one time close. They're not close anymore. That is clear. And the families aren't close. They need to maintain a distance. In some ways, it's better that Mr. Moody's family didn't come here today because you'd all be in the same courtroom and I'd have to let the Moody's leave first. And then folks who are here for Mr. Glasper would need to wait to leave. Be smart about how you handle this going forward. It will not benefit Mr. Glasper if folks associated with the Glaspers are picking at the Moody's. And the same goes to the Moody's. You need to stay in your lane. And if you have concerns, Ms. Moody, you share them with Mr. Arrington. He gets them to me. And if I need to find people in contempt, I can do that. I can bring someone into court and say, you need to knock this off. And if they don't knock it off, I have ways of dealing with that will have an impact. So keep papers. If you get texts, if you get something, get that to Mr. Arrington. He can get it to me or ultimately the judge to whom the case is assigned. And we can do something about that. I'm not taking sides on this. Well, I'm going right down the middle saying, folks associated with Mr. Glasper, hold your grief and don't direct it in the wrong direction. And folks associated with Mr. Moody, you need to process what you're processing. Don't compound the tragedy. We have one lost life. And it doesn't need to get more complicated than that because that's already something that no one can fix. Okay. I appreciate Ms. Moody, you sharing that first part. The other stuff, I hear you. I've decided what I've decided right now. Mr. Arrington's going to get more information about your son's case. And if we need to revisit it, I will gladly do that. We will make time for that. Okay. All right.
Yes, Your Honor.
Mr. Arrington, anything else?
That's all, Your Honor. Thank you.
All right, thanks for your time. And again, I'm sorry for your family's loss. Mr. Abate, anything else?
No, Judge.
All right, thank you, everyone.
Judge,
Thank you, Judge.
You're welcome. Yes. Yes, sir. You don't have anything on the other calendars today?
Not till this afternoon.
Okay.
One or 1:30.
Are people allowed back in the building now or not?
I think we're still in the same box.
Okay.
Just have one track. He's in the back over.
Investigator Phillips? Stay right there. I just want to make sure. So you are here? I'm going to do this right now, and then we'll go to the next calendar. Is that it so far?
Yeah.
Okay, great. Did you come by yesterday too, or this is it?
I did.
Okay, sorry, but yesterday was kind of crazy.
Yeah. I figure I'll let you handle that.
Yeah, thanks. I would have traded with you. All right, you want to come on up? So you're trying to get Dachshund, not Freaks One Me, is that right? I don't know much about Instagram because there's the main account is Freaks One Me, some subsidiary account.
So Dachshund is his main account. The Freaks One is the back.
Okay, so they're separate accounts.
Yeah, the separate accounts. So I want the IP address stuff because I already got those warrant for the Dachshund that side.
Okay, got it.
The IP address is from that part.
Got it. And so this is just going to help you figure out where is this? Okay, got it. All right, you swear affirm the contents of your affidavit are true and correct to your best of belief and knowledge? All right. This presiding week is always a little zany, but it typically doesn't have yesterdays. That was a little special.
Yeah,
Yeah, I know. I've never had that many in the courtroom before, because usually you assign a pool camera, but no one wanted to be the pool. They weren't sure how this was going to work. All right. No problem. Otherwise, you'd be waiting until whenever we break for lunch. I don't know when that's going to be. This guy sounds not like a super safe guy, so be careful. You got a sign right there. All right, good luck. Oh, well, I noticed when it was describing all that, the music and everything. Okay. Well, maybe they can spend some time together.
Exactly.
All right, good luck.
Thank you, sir.
Okay, let us pivot. No?
Yeah, we good, but I gotta get the 3 females. They didn't bring the 3 females.
Okay. Are they on this morning's calendar?
Yes. 11 o'clock.
11 o'clock. We've got,
I think one's on the 10 o'clock.
Nick, we don't have a 10 o'clock. I have an 11 and a 1. But I do have 3 females on the 11th.
Gibson, Jones,
Jones, Holloman,
Holloman.
and it's Easley Manson.
She's out.
She's on bond.
Yeah.
Okay. What was the other name?
You do got a 10 o'clock.
I do?
I'm sorry.
Oh.
That's Gibson, right?
Wow, I'm late for the 10 o'clock.
She's a female.
Yeah.
Is this the 10 o'clock?
If you look on out at the motion, I believe it's on there.
Yeah, good morning. I have Gibson on the 10 o'clock.
Great. Well, we'll do that first. Let me, but so you need to bring those folks up. All right. So we're gonna take a 5-minute break. Is 5 minutes enough?
Yes.
Okay. You have some potato chips if you need it.
10 minutes.
All right.
Judge, my apologies. Before you break, I just wanted to kind of make the court aware, I am actually in Montgomery to testify today. Mr. Peoples does have all of my announcements, but in the event that I just log off without word, it is because I've been called into the courtroom.
Have you been indicted in Montgomery?
No. I am just a witness.
Okay. All right. Great. As long as Mr. Peoples can speak for you, then we're good to go. So the deputies have asked for 9 minutes to be able to move inmates up and down because it'll be 11:30. We'll start, Mr. Toller, with your case with Ms. Gibson when we reconvene. I'm sorry we're running a little bit late. These bond hearings took a long time.
It's more than okay. Thank you so much, Your Honor.
All right.
I'll see you 11:30. Bye.
Give me that box.
I saw this last night.
World famous. Yeah, a bunch. You want one? Two. She get the job at the diversion center, or she get the She's been looking at it a few good opportunities. I know it's sad, but it's good for her. She deserves better in the office and management here. You know.
Yeah, they wouldn't.
Okay. Yeah, that was last night. But
Oh,
I gave them to the reporters. Till 9, so I brought this down.
Do you have a copy?
I'm trying to think.
I'll check my emails. Yeah.
That's Toller's, so it's not yours.
No, okay, it's private attorney.
Okay, nobody.
Perfect.
Yeah.
We have 11 o'clock. Toller.
No, I was trying to print the 11 o'clock.
I usually just save them.
Okay.
But I don't know why when I send them to print, they're not printing. You need to call IT.
Yeah.
Yeah.
Ms. Feely, do you by chance have any updates for me on position 3 or 5?
So I believe position 3 based on my
I'm sorry.
discussion.
Yes. Might be both, they're both yours, correct? Okay, I'm sorry, go ahead.
I think 3 may be a plea. I got to talk to him again today. I talked to him last week.
Okay.
And then what was the other one, Jasmine?
5.
Oh,
I think that she, make sure. So she is good for now. She, not that she's not going to accept the offer, but she isn't required for today, and she had other stuff, so she's not. Her presence isn't required for the kind of motion that's on today.
oh, okay.
But she will do that probably at the next, like at final.
Okay. Okay, sounds good.
Thank you.
Miss Tucson, are you on? I just asked this question.
Hey,
How are you? How are you?
Good, how are you?
I'm well. Can you do me a favor while we're on a little break? Can you check on position
Sure.
6? I think that was handled by Judge Barwick like 2 weeks ago.
Let me see. No problem. Let's see real quick. Mr. Buford?
Yes.
All right, I was looking at that yesterday. Because I remember, let me see. I might have him pulled up because I was looking at it the other day. Let me see. He has a lot of different cases. So that's 369. You are correct. Let me see. He had court with Officer Brown. Looks like the 27th of July.
Yes. Okay, that's what I saw too. I just wanted to make sure.
And it was on 22 SC 182215 and then 22 SC 182067. I don't see this one though, because ours is 17 SC 153369. Hang on. Let me see if there's any revocation orders filed. Revocation of probation. Okay, that was mine from last year. Yep, she did that one too. You want me to just shoot you a copy real quick, just so you have it?
Yes, that'd be amazing.
Okay, yep. Okay, yeah, she did that one too. He
Okay.
stipulated to this case, so I guess that's one less thing today, right?
Yes, yes, that's
Okay.
perfect. Thank you so much.
Oh, do you want all of them or just this one?
Just this one is fine.
Okay, no problem.
Thank you, Ms. Tucson.
Anytime.
How are you, Ms. Rivers? Do
Vacation.
you have anything fun lined up? Right?
Us. I'm sure.
That sounds about right.
Oh. When I came, no, and I was like, which way you coming today? Okay, so you know the underground ride part, the other underground parking lot, there's like a lot of media kids. There was a guy that I thought was media person, I guess he was like dressed nice and quick, and there were all these people like holding their cell phones, like walking behind him and like taping whatever he was saying, and all the other media people like trying to know what was happening. So I asked him, I was like, oh my gosh, where did I miss? Because he was like repeated, and then like all of the he looked at me first, and then all of the regular spectator people were like, oh, what'd you say again? And let me get that. And it started following up the other. And so he stopped being nervous and asked certain people, like, what did I just miss? And they were leaving. So I'm like, oh, I was like, oh, God. It's like, no, so really is. Let me get that again. I was mainly concerned because like I almost walked into the cameras. Definitely don't want that. I love this comment from George. Do you know who will host the drug free cocaine? That's a good way to put it. That is a good way to put it. Oh my gosh.
Might need to go back.
I do. Who do you have? Well, I might. Let me see.
Color back. Grab the color back.
Is everybody here? Can I see, Rasheed Grimes? Yes.
I'll tell you right now.
I hope it won't be too bad. Are you gonna be here all day? So, this guy. Just talk.
Just remind me.
Yeah, and you can. But he can start talking to you.
Court on order, Macy.
I'll give you enough time.
Yes, sir.
Okay.
Yeah, council document on 2, I think it is.
Okay.
Yes, sir.
Mhm.
All right. Mr. Toller, are you ready if we get Ms. Gibson out here?
Yes, I am, Your Honor.
Great. Mr. Peoples, are you ready?
Yes, Your Honor.
All right. We just need to get our court reporter out here so you can let those folks stay talking. I'll get Ms. Gibson's case up on my screen. Is Mr. Horton here? How you doing? All right. Are you here on behalf of Mr. Render?
Yes, Your Honor.
And you are?
Attorney Green, VER. EEN.
Great.
Regarding that matter, I reached out to the state with the several attorneys that have been assigned to the case. And, at this juncture, we privately.
Okay. Yeah, we need to figure out who's handling it for the state, but we'll do that in a sec. I was just seeing who all was here. Is Ms. Easley Manson here? Yep. Okay. Who else? Mr. Elder, I saw online, which is good. Okay. Ms. Nelson, is Ms. Rivers back there?
No, Judge, she's not.
We're just waiting on Ms. Rivers and we'll get going.
She's coming, Judge.
Judge McBurney.
Yes, ma'am.
Position 6, Dante Buford, that revocation has been handled by Judge Barwick.
Okay.
So I'm gonna go ahead and Sheriff's Office take it back. That's a good order.
That's all right with me. So does she have something that got indicted or?
There's 2 22 SC cases that were in Judge Barwick's courtroom, and she handled the revocation of this case on July 27th.
Great. Okay. So, and you've told Mr. Buford that or? Okay. All right. Let me know when you're ready. Great. That's okay. Let's bring Ms. Gibson out, please. If she can come to the podium. One second, Ms. Gibson.
Okay.
There we go. Okay. This is 23 SC 187457, State versus Gibson, and your lawyer, Mr. Toller, has been waiting patiently on this call for a while. You can see him on the screen in front of you, and the prosecutor who has your case is Mr. Peoples, and he's the guy with glasses. So we are on because you missed court, and or at least you weren't at court when you were supposed to be in court in June of this year. I issued a bench warrant. That bench warrant caught up with you, and Mr. Toller has filed a motion to set aside or lift that bench warrant. So I'm going to hear from him about maybe why you missed court, and then I'll see if Mr. Peoples agrees with Mr. Toller or disagrees, and we'll figure out where you're going to be as we continue to move your case forward. Okay. All right, Mr. Toller.
Good morning, Your Honor. I was to discuss bond and the bench. Well, my client was the day that she was arrested. She was taken to the hospital and then they released. So she's never actually made bonds, never actually been into the jail and fingerprinted and processed. So whatever address that they got at that point was the incorrect address. So she didn't get noticed to be in court is why she missed court. As far as being heard on bond, and I believe that I just want to give you some background on her and make a better presentation across the board. She resides at 2824 Dale Creek, where she takes care of her 85-year-old grandmother who's lived with her, and she's a sole provider past 8 years. She also has a children aged 15, 6, and 3. The 6-year-old has autism as a special needs child, so she spends a lot of time with children. She's a graduate of Norfolk State University, Your Honor. If my arithmetic is correct, she's 45 years of age, no criminal history whatsoever. She has her own business, Your Honor. She has a brick and mortar business here in town that's located at, it's called Vintage Karma Boutique. And that is located at, get the address here. It's here in Fulton County. What? That's right. I said Morrow. I'm sorry. It's 1389 Mount Zion Road, Morrow, Georgia. Excuse me. You know, she's operated that business for a number of years. It's a mail order business and it's a brick and mortar business where people come into her boutique and shop. And she runs and manages that business herself. Yeah, this dispute was between her boyfriend's ex-girlfriend and my client got some type of dispute. There's some allegations back and forth. My client and her boyfriend were arrested. Ultimately, my client was charged with assault with a deadly weapon. The boyfriend with battery. The battery charges were ultimately dismissed by Fulton County State Court. He presented a video to the state. The video showed there was no battery, never unlawfully touched the alleged victim in this case. The victims made some untruthful statements that led to arrest. I don't believe there was ever a gun involved in this. I'm not sure if anything took place the way that the alleged victim claims it did. This is basically a jealous ex-girlfriend who is the mother of my client's boyfriend child. That's the connection between the three parties or the two parties involved in this particular matter. Your Honor, so my client lives, works in the area, substantial ties. I've spoken with her aunt multiple times, her cousin multiple times, boyfriend as well. Again, she runs a reputable business here in town. She's not a flight risk. She's not likely to reoffend. This is, I believe, the first incident of any kind with the alleged victim, and I believe this is a little bit of a fabrication. But at any rate, regardless of that, I understand the charge is serious, but we're asking for set aside the bench warrant and for a reasonable bond, Your Honor.
Okay. Let me ask a couple questions about that. I'm looking at the indictment, and the alleged incident occurred a long time ago. So June of 2020. And what you were explaining, Mr. Toller, is that Ms. Gibson may well have been arrested at that time, but she wasn't well, or for some reason, instead of going to the jail, she went to the hospital.
I was 7
I believe
months
she was,
pregnant.
I believe she was, if my memory is correct, I believe she was pregnant then. And because of some kind of issue there, they took her to the hospital, and then where she was released.
Got it. That would explain why there's nothing in the docket till the indictment, which was handed down in May of this year. So it's something of a direct indictment. There wouldn't have been anything in place. I guess there might have been an address from 3 years ago. And that's why there's no bond. So it sounds like if I am going to set aside the bench warrant, then it's not that simple. I also need to set a bond so that Ms. Gibson has some paperwork associated with these charges. Mr. Peoples, what are your thoughts about how to move this along?
So, Your Honor, as it relates to the bench warrant, Miss Gibson clearly has been found, and which was the purpose of the bench warrant, to bring her to court. So I would defer to the court on that aspect. However, as it relates to bond, are you asking what the state's thoughts are on that part?
I am asking, yes, sir. Both questions. You answered one.
So as it relates to the aspect of bond, I spoke to Miss Shantae Thomas this morning. She is the one of the alleged victim in this case. The state's concern is that Miss Gibson potentially is a risk to Miss Thomas. While I will stipulate that looking at her criminal history, there's not an indication to me of any FTAs or felony history from the information that I have available to me. But according to Ms. Thomas, as recently as June of this year, I believe that according to her, that Ms. Gibson was riding by or attempting to provoke some sort of altercation with the victim. So the state is concerned about that. So if the court is inclined to grant a bond, we would ask that it for sure include a stay away from Ms. Thomas, and as well as make it a substantial bond as well.
Okay, well, thank you for sharing that. Do you have any sense, Mr. Peoples, I don't know where Dale Creek Road is, but if that is anywhere near where Ms. Thomas lives?
I am not sure, Judge. I think Ms. Thomas is on Zoom. I think she may be able to clarify the distance of where it is.
Okay, and I don't want Ms. Thomas to reveal her address. I just want to know how far apart Dale Creek Road, whatever neighborhood that is in, is from wherever Ms. Thomas lays her head.
Okay. Ms. Thomas, are you, if Your Honor, if I could inquire, Ms. Thomas?
Sure.
Ms. Thomas, will you raise your right hand?
You don't need to be sworn in, Ms. Thomas. I don't want you to give me your street address or anything like that. Do you know where Dale Creek Road is?
Yes, sir.
And ballpark, how many minutes away driving is that from where you live?
Less than 10 minutes.
Okay. And if you're walking?
I want to say 20.
Okay. All right. I don't want to go into any facts here because I don't want to have a back and forth other than this one question. What you've relayed to Mr. Peoples or someone working with the DA's office is that you believe that since this alleged incident from June of 2020, Ms. Gibson has tried to get up in your business since then.
Yes, sir.
Okay. All right. That was important for me to hear. Thank you for joining us on this call. Mr. Toller, do you have a dollar amount that you're aware of that, I don't want to set a bond at $1 million because that's no bond, but also to Mr. Peoples' point, given Ms. Thomas's concern, I couldn't give a signature bond anyway for these charges. I don't want to understate the significance of the situation. What is a range that is reasonable for Ms. Gibson?
Yeah, in light of the fact she's a business owner here in the city, her age, lack of criminal history, children. This is an incident that happened 3 years ago. There's been no further incident between the two. There may be a naked allegation that is a drive-by or something, but no other contact or incidents between the two parties. Your Honor, I was thinking 7,500 would be reasonable. And again, as far as I know, there's no gun found. There's just an allegation. I think they may have had some type of altercation, disagreement, but I don't think there's no harm. Been no harm at this point to the alleged victim of any kind. Just these are just allegations or words. I think $7,500 would be more. She's not going anywhere with a business and 3 kids in town, and her 85-year-old grandmother living with her. She's not a flight risk. She's going to appear in court. She's a very college graduate. I think $7,500 is more than reasonable.
Okay. Ms. Jackson, good morning. Do you have any criminal history information on Ms. Gibson?
Good morning, Your Honor. She has 2 cycles. The last arrest was February the 19th, 2017 in Fulton County for criminal damage to property in the 2nd degree. There was no disposition for that arrest. Nothing in addition.
Thank you, ma'am. Ms. Gibson, who has been taking care of your grandmother and kids?
1 kid is with his grandmother. 1 kid has been with his dad. The autistic kid has been with his dad. And the other child has been with his paternal grandmother.
Okay.
Because he's young.
And how about your grandmother?
My grandmother, my cousin, is going by the house to see on her.
Okay. All right. Mr. Toller, let me see here. Fence. I'd like to take care of arraignment today as well, so we can get a scheduling order in place and move this along. Are you going to be handling this for Ms. Gibson, or are you just on for bond?
At this point, I'm just on for bond. There's some indication they may retain my services, but at this point, I'm unsure. At this point, I was only retained for bond. Yeah, Ms. Gibson may share more with you. I'm not sure.
So, Ms. Gibson, what I'd like to do today is also handle your arraignment, but that needs to be with a lawyer who's going to be representing you through the completion of this case, whether it's a plea or a trial or a dismissal or whatever happens. Are you planning on retaining Mr. Toller, or is that something you can afford? What do you know about that?
Yes, I can retain Mr. Toller.
Okay. Mr. Toller, I'm not going to have the two of you engage in the financial exchange right here. I am going to require you to do that with Ms. Gibson in short order. And if you are retained, I'm assuming you'd be comfortable waiving arraignment. It's not required, but if you'd be waiving arraignment for Ms. Gibson, that's something you can do simply by filling out the waiver form. That would also constitute your entry of appearance. And then we could get a scheduling order in place to make sure the case moves along. What I'm going to do is ask you, Mr. Toller, to let Ms. Nelson know, looking at a calendar, by August 25th, whether you are on the case or not. If you're not, then I'm going to bring Ms. Gibson in for an inquiry calendar to find out when she's going to get a lawyer, and if she can't afford one, we'll see if she qualifies for appointed representation. If you are representing her, then by the 25th, you can file that waiver of arraignment and entry of appearance, and you'll be moving the case forward for Ms. Gibson. Does that work?
Absolutely, Your Honor. That sounds great.
Okay. Ms. Gibson, I am going to lift the bench warrant. Were you arrested at your house? Where'd you get picked up?
I was calling 911 because my bank card was missing. And when I looked at my statement, it was being used at a store. So I went to that store and called the police so they can get the footage. And then he ran my license and said I had a warrant. So that's how I got arrested.
Look at that. So you were reporting a possible crime and got arrested. Still call 911 when there's a problem. Just don't have any warrants. I'm going to set a bond. It's a $10,000 bond through the sheriff's 10% program. is $5,000 for count 1 and $2,500 each for counts 2 and 3. The way the sheriff's 10% program is that you will put down some money. You get that money back minus some fees when your case is resolved. So that's how it's different from a bonding company. You actually get your money back or whoever's money you put up. Special condition of your bond, number 1, is that you have no contact, direct or indirect, with Shantae Thomas. You know who that is. You need to stay away from her. If you know her phone number, don't text her. If you know her online presence, don't post there. If Ms. Thomas presents evidence to the prosecution that you've been reaching out to her, whether it's to say, hey, I'm sorry, or I'm gonna chop your head off, anything, I will take away your bond and you will be where you've been until we resolve this case. That is the most important condition of your bond. Just stay away from Ms. Thomas. Now, it's not a trap. If you're at McDonald's and she runs in and takes a selfie with you, that's very different from you're driving by real slowly by her house and she films you go back and forth in front of her house. Or if you walk up on her and she films that, or you're sending something to her, or anyone on your behalf. If you have shared acquaintances and other people are saying, hey, we're talking with Ms. Gibson and she says X. Ms. Thomas gets that, shares it with the state. If they ask me to revoke the bond, I likely will. Ms. Thomas needs to be able to go in her direction while you go in yours. Any questions about that? No? Good. Okay. Mr. Peoples, any other conditions to the bond?
Your Honor.
Hold on.
No, Your Honor.
Okay. Yes, ma'am.
But to my knowledge, my grandmother's address is on the west side of town. And to my knowledge, the last place that Shantae Thomas was residing was in Decatur, Georgia.
Okay.
And when my grandmother lives is by Rice Street. So
okay.
The 10-minute thing is.
You know what? The distance is the distance. You're not next door. And I've set the bond. I wouldn't set a different bond if it turns out that Ms. Thomas is in Decatur. I'm not asking her to tell me where she is these days. 10 minutes, 20 minutes, that's far enough away. That if you end up there, that's purposeful. If you lived on neighboring streets, you could just legitimately be rolling down the street, minding your own business, and then she's taking pictures of you. But if you end up in her space, that says to me, as the one deciding what to do with your bond, that you went there with a purpose, and it wouldn't be a purpose that I'd be okay with. So I appreciate you flagging that. And the further away she lives, the better it is for you, because then you're not ever going to bump into her, which is my goal here, is that you two don't bump into each other till we resolve this, whatever resolution means. You need to post that bond and connect with Mr. Toller, because if you're going to retain him, he's got about a week and a half to reach out to my staff saying, I'm on board, I'm going to do this, and then we can move your case forward. Okay? Any questions? No. Mr. Toller, anything else?
That's it, Your Honor. Thank you so much.
All right, before you guys go, let me check one thing. Nope, that's it. I covered it. Thank you.
Thank you. Maybe we excused.
Yes, sir.
Thank you, sir. Good to see you. Bye-bye.
All right, at 11:59, let's get to our 11 o'clock calendar. Plea and arraignment, position 1 is Andre Williams.
That would be my case. You're trying to review with this arraignment calendar and reach out to the DA's office to see if we can resolve some stuff.
Look at you, like Tiger.
But I barked up the wrong tree, unfortunately, initially with the DA's office. But I think Mr. Jordan is taking a look at this case for me. It's from April of 2018.
What?
So I'm hoping.
Don't be discouraged. Keep reaching out, because there are PDs who get the calendar and look at certain charges and say, this is one I know we can take care of at plea and arraignment. Okay.
I just need an offer from Mr. Jordan, which he emailed he's working on. So if we
Okay. I don't see Mr. Jordan on this call. Ms. Willingham, are you handling the Andre Williams case?
I am not, Your Honor. And from my review, it actually looks like it's going to be a sex assault unit case. I believe ADA Marsh will ultimately handle it. I'm not sure when her switch and Ms. Hall's switch actually is scheduled for, but it's going to be my understanding that that will ultimately be Ms. Marsh's case.
Okay, so that switch is being handled poorly. Ms. Hall is gone. Ms. Marsh is not here. So there's no one is the answer. And we're just supposed to raise our hands in panic if we have an SAU case for the
No,
next.
Judge, I can handle it for today, but I know that Ms. Nelson puts our names on the calendars, as well as if there's an attorney in the courtroom who needs to know who ultimately they wanted to reach out to.
Okay, we'll put Ms. Marsh's name. Ms. Marsh allegedly starts here next Monday. So in the meantime, we've got Mr. Williams in court. Good morning, Mr. Williams.
Good morning.
I'm Judge McBurney. How you doing?
How you doing?
Okay. Ms. Feely, I know you made some good efforts to see if this case could be sorted out now. That's not the answer we got. Is Mr. Williams waiving arraignment?
We do waive formal arraignment. We would like to address the bench warrant as well, if we may.
Okay, let me look at that. Okay, 2018. All right. So Mr. Williams was indicted in 2022 for something that allegedly happened in 2018. So that was 4 years old. And now here we are in 2023 with a bench warrant that was entered in 2022, finally catching up with them.
Yes, Your Honor, and I don't know who may be handling this for the state.
Well, you should start talking, and then I'll turn to the screen and someone from the state can talk.
Perfect. So Mr. Williams unfortunately got arrested in Gwinnett County for shoplifting, and Gwinnett County handles shopliftings differently than our county, it would appear, because he got sentenced to prison where he was when he missed his court date. So it's our position that he had a legal excuse for not appearing. And so we are asking the court to lift his bench warrant. And he's been in jail now for 95 days here in
Fulton after his Cobb County shoplifting.
After the Department of Corrections, where he completed RSAT.
Okay, got it. Where would Mr. Williams go?
He's going to be staying with his sister, Lisa, in the metro area.
Okay, I've got an address on Warren Street and an address on McDaniel Street. Neither of those?
Warren Street.
Okay, that's where your sister stays?
Yes, sir.
Okay, got it. And does your sister know that you would be heading in her direction?
Yes, sir, she does.
Okay, all right. What's the bond? There may be a bond in the system. I'm sure the surety will say, oh, 4 years ago, we're done. I guess he posted bond. Okay. Because there was a bond order for $6,000. Okay. All right. Mr. Peoples, Ms. Willingham, who's handling this for the state?
Well, Your Honor, I guess we're playing Attorney Willingham and I are playing chicken here. I guess I'll take it over. So, Your Honor, my understanding from this is that he was picked up in Gwinnett County on the shoplifting, and is Attorney Feely representing that's why he failed to appear to court?
He had the shoplifting and then he had state prison time as a result of the shoplifting. And so she's saying that on whatever day we would have had plea and arraignment, May of 2022, Mr. Williams wasn't here. He was in DOC custody. Gwinnett custody or DOC custody?
He was in DOC at that point.
Okay. Either way, not available to us.
I see. So then, Your Honor, then we would have no problem with the court lifting the bench warrant, if that's the case. We would ask that if the court is inclined to do so, that all of any conditions of bond remain.
Okay, and that bond order was no further contact with some bad handwriting, but it's the alleged victim in the case.
He hasn't since 2018.
Who is that person to you? Is that a girlfriend?
Ex-wife.
Ex-wife, okay. So you've been staying away from her?
Since 18.
Good, you'll keep doing that?
Yes, sir.
Okay. What kind of work do you do?
Landscaping.
Okay. It's hot out there.
Right.
Yeah.
You get right on it.
Drink water.
And then I had got a certificate, a safe service certificate while I was in Coastal too. So I'll be doing some cooking too.
Excellent. Chef. You were down at Coastal CI?
Yes, sir. I did RSAP.
Okay.
And I finished it.
Excellent. Okay. So I'll set aside the bench warrant and reinstate your bond. You'll need to stay away from your ex-wife.
Yes, sir.
Ms. Feely, you're waiving arraignment. If you'll fill out that paperwork, we'll get a scheduling order out, and maybe Ms. Marsh, when she makes landfall here next Monday, can start engaging with you on this.
Sure. Thank you so much.
Okay. All right. Anything else,
Your Honor,
Mr.
for the record,
Yes, Ms. Willingham.
Your Honor, I just wanted to note for the record, I do believe, I think last week or the week before, I did notify Ms. Feely that I thought it would be Ms. Marsh's case. So I think that Ms. Marsh may also be aware now, but I do believe I sent Ms. Feely an email stating the same.
Okay. Well, and in Ms. Marsh's defense, she is currently assigned to another judge. She can't be in two places at once. My grouse is with SAU, leaving no one here. And then we see what happens is that the defense attorneys aren't quite sure who to engage, but we'll work through it. All right, position 2 is Rashid Grimes.
He's fine, Judge. He's in custody. This will be a plea today. I just need to speak to him once more.
All right, we'll come back to that. I don't recognize this attorney name. Will that be yours, Mr. Peoples?
And that's mine for the defense.
For the Grimes case, that's me, Your Honor.
Okay, but
it came from non-complex.
Okay, but who's handling it? Okay, all right, great. That'll be a plea. Jonathan Jackson.
Similar to Ms. Wood's announcement, I spoke with him last week and gave him the state's offer, and he couldn't give me a definitive answer, but that may be a plea.
Okay. And Mr. Peoples, you can cover this plea for Ms. Willingham if she has to run off to testify?
That's correct, Your Honor.
Okay, great. We'll do that too. Kenley Horton is here. Ms. Vereen is here. Are you affiliated with Mr. Render, same firm?
Yes, same firm.
Okay, fantastic. Who's handling Mr. Horton's case for the state? It was Miss Charles, but that was a long time ago. I lost track of, I don't know which unit she was in when she had this case, and who's got it?
Checking right now, Your Honor.
Attorney did email us yesterday, said it was a hall.
Your Honor, it's a complex case. That would be me. But I see it says complex, but
There was some specialized unit angle to it, I think. Although Miss Charles was in your role at one point, so maybe I'm mistaken. Let me look.
Your Honor, I do apologize because when I saw Attorney Charles on here, I thought it was her, so I'll double check it as well to see. But I will.
It may be perfectly yours to handle. Let me find the indictment. So yeah, Miss Charles was serving discovery early on, and the alleged victim, Natoya Knight, Do you know the relationship between Mr. Render and Ms. Knight? I mean, not Mr. Render, Mr. Horton and Ms. Knight?
That's the alleged victim. There is a relationship.
Stranger? Okay, yeah, so Mr. Peoples, I think this is your case.
Okay. Then it will be, Your Honor. So I do apologize. I have not, because I imagine that it was Attorney Charles. I know that I have not submitted an offer for this. So I do apologize to the court, but I can have an offer extended today.
Yeah, maybe when we are handling it, well, you're taking these other pleas. Mr. Horton has had a long and winding road to get here, and it's important that we stay focused on his case. We had to line up some special procedures in court for him, and he showed up for those, and it's a little frustrating that the state has dropped the ball on this one. Ms. Vereen, are you in a position, if we're working on something else, to talk with Mr. Peoples about this?
Yes, I am. I do know that Mr. Horton has something to do around 2 to 3, so.
Okay. All right. Well, Mr. Peoples, you may want to dive into that file. Why don't you guys take a seat? I'm not going to keep you here too long. If the state's not going to be ready to go forward, I'll get you out of here. Pardon me? On our 1 o'clock?
Yes.
Okay, great. All right. So, Mr. Horton, take a seat. I promise we'll get back to you. All right. How about Ms. Easley Manson?
That's my case, Your Honor. I need to speak with Ms. Easley Manson. I do have an offer to relate to her, but.
From whom?
From Ms. Moody.
From me, Your Honor, it's going to be ADA Willingham.
Great. Okay. So we've got all the people we need. So you wanted to, what were the motions we were going to hear today?
Motion to relieve surety. I'm not even sure her presence was required for such a motion.
It wasn't, but why don't you talk with her? And then we don't need to worry about the surety. Okay. We took care of position 6. Mr. Elder is on, and I think Ms. Hill is on. Let's get them on the big screen. There's Mr. Elder and Ms. Hill. Fantastic. We have a lawyer for Mr. Elder. How you doing, Ms. Hill?
I'm good, Judge McBurney. How are you?
I'm well. Thank you for joining us. I think we may be literally at the starting gate with this case, despite it being an indictment from last year. This may be just a question of, are you waiving arraignment or what? Let me get the case open here. No, oh no, Mr. Elder had a lawyer. I stand corrected. And we got the final plea. All right, Mr. Rosenblum. And then the struggle was getting a lawyer for Mr. Elder. So why don't you tell me, Ms. Hill, where you feel like you are in getting up to speed on Mr. Elder's case, because really its next destination would be a trial calendar.
Well, Judge McBurney, so I have been in contact with ADA Peoples and we've had some discussions. However, I was just given discovery on this case yesterday, and I actually still have not been able to open it. I'm downloading it again for the 3rd time. It's a rather big file. So I have not been able to really go through and address the merits of the state's case against Mr. Elder. And it kind of is just going to depend on what we see, whether or not ADA Peoples and I can come to something, as well as what Mr. Elder would like to do after I've advised him of the evidence and his rights.
Sure. Okay. That's a reasonable outline that you've provided. I'm trying to see what the co-defendant did. Okay, got it. So what's a fair timeline for you? I do want to put it on a trial calendar, but I'll push it out a little ways. One, because you may look at the discovery and say, wait a minute, there's a motion to suppress here that we have to hear. But you may look at it and say, no, the evidence is the evidence, and it's a weak case or it's a strong case. And you and Mr. Elder will come up with a perspective, and maybe there's a meeting of the minds, or maybe there's a trial. How far out should I set it for a trial calendar to let you wrap your arms around? It's a burglary case, so it's not a ton of discovery, I hope, but you still need to get familiar with it.
Correct. It's hard, given that I really haven't looked at it yet, Judge, but I would definitely say it's probably doable this year. It's not an extremely complex case, it's just, I haven't, so definitely doable this year.
Okay, well, why don't we say I've already, our September calendar is pretty locked in, and that would be right around the corner. So how about the October calendar is kind of spoken for, I think, or is that the September and October is really the same thing? So we'll do the November trial calendar. Sounds
great.
Do you know what those dates, when we're calling that calendar? Okay, all right, so November trial calendar. Mr. Elder, that doesn't mean necessarily that you're locked into a trial. Once Ms. Hill has had a chance to look at this discovery, she's going to connect with you and say, this is a terrible case for you, or it's a great case for you, whatever her professional assessment is. And then after you two have huddled, she'll engage the prosecutor to say, hey, we got to work this out, because she'll know what you're comfortable doing, and you'll have received her advice. So it may work out, but if it doesn't, then I'll expect you to be in court, not in your vehicle or your home, for the call of the November trial calendar, which will be kind of early November. But that gives you and Ms. Hill a bunch of weeks, really months, to look over this and see what you can sort out. Do you have any questions, Mr. Elder, about that process?
No, Your Honor.
Do you have, I'm sorry, go ahead.
Well, my co-defendant, I found out, pled guilty to the charge, and I'm just
right. But if I'm going to give you a hypothetical, you've got a crowbar and I've got a crowbar. We both break into a house and I plead guilty. You still got some business to deal with. So the fact that Mr. Swindle pled guilty doesn't mean that he said when he pled guilty, Colby Elder had nothing to do with it. So that's a conversation for you and Ms. Hill to have. Swindle dealt with his business. You're going to need to deal with yours. It may be a very, very different outcome from Mr. Swindle's. You may not be similarly situated, but I get co-defendant cases all the time, and they typically result in two resolutions, not a resolution and a dismissal. But you need to spend some time with Ms. Hill so she can talk to you about the evidence and figure out which way you guys want to go with that. Do you have a good way of contacting Ms. Hill? Because what I don't want to have happen is November rolls around and Ms. Hill says, dang, I haven't been able to track Mr. Elder down. And Mr. Elder's saying, who's this Ms. Hill?
Yes, Your Honor, I do have a good way to get in contact with her. I have her phone number now.
Excellent. And Ms. Hill, do you feel like you have good contact information for Mr. Elder?
I do, Judge McBurney, I do.
All right. And then the discovery that you got, you're trying to open, you got from Mr. Peoples, so you know how to get in touch with him.
I do have good contact from Mr. Peoples as well.
Then
it's a little surprising.
Yeah, but I like that. That's exactly, those are the lines of communication we need. So Mr. Elder, I'm going to move your case to our November trial calendar. That calendar is called on November 8th, but you'll get notice of that way in advance, and that is 3 months out. So let's try to move this along between now and then. And Ms. Hill, if you run into any obstacles in terms of getting discovery and you don't feel like Mr. Peoples is fixing that for you, please reach out to Ms. Nelson, and I'll just get the three of us on a call to say, hey, we got to make this work. Okay.
Okay. I appreciate that. Thank you.
All right. Mr. Peoples, anything from the state?
Nothing further, Your Honor.
All right, Mr. Elder, you are free to go. Thanks for hanging in there.
Thank you, Your Honor.
And Ms. Hill, I don't know if you've got other cases or if that was it.
Not today, but I think I will see you tomorrow.
Sounds good. See you then.
All right. Thank you.
Can we go back to number 5? Ms. Easley Manson, I did relay the state's offer and she's not interested, so I was just wanting to excuse her if we could.
Sure, except, yes, let me just see what's next so we don't leave.
She's on the September 7th final plea calendar.
Excellent. Okay, so Ms. Easley Manson, you'll be back here in a little less than a month to have one final opportunity to see if we're working your case out in a negotiated way. And if we don't, then we just make sure it gets on a trial calendar, okay?
But that was why I came for last time, is why I'm here today. It's for the same reason.
Well,
Call her when we spoke the last word, and I never got a phone call back from her because
the person that pulled the gun out on me and my kids, you guys dismissed her case. But you're keeping mine for what reason?
Okay, so don't you guys me. I don't get to dismiss things. The state may have dismissed charges against a guy who pulled the gun on you. Okay, whoever it was, you've got charges, and today, in theory, we were going to deal with a motion that the bonding company had filed saying they wanted to come off your bond. If they had shown up and came off your bond, I might need to take you into custody, but that's not happening today because they didn't show up. So I sense clearly that you're frustrated. You need to come to court when you need to come to court. It's not an optional.
I've been coming to court.
Good.
That's the thing, I continue to come. So for those who want to come off my bond, I don't understand why.
It could be that it's an old case and they've been on.
3-4 years ago.
Yeah, so they may be trying to come off the case, not because you're hard to find, but because they're not obligated after a certain number of years to stay on the case. But I'm not.
They're liable to go back to jail because they don't want to.
No, if that's why they're doing it, no. If they're wanting to come off it because they can never track you down, that's a different issue. But if it's the passage of time, that's more a problem for the state because this case got old on their watch, not any problem for you. But we ended up not working through that today. There was a chance to maybe do something because it sounds like there was a new offer made by the state. It's not one you like, and that's okay. You don't have to like their offers.
She came back here to me. She asked, well, what's going on? I said, we're supposed to dismiss the case today because you said you didn't want me to keep coming back down.
Okay, so your lawyer doesn't get to dismiss cases.
I don't have a lawyer. I'm saying when I spoke with her, the last court date that I had in here because I was a few minutes behind.
The issue here is I did not realize Ms. Easley Manson got notice for today. I was expecting to see her for the final plea count.
Right,
beforehand.
Right.
So because we didn't have contact prior to this, I think she's just really frustrated, which is why I wanted to get her excused.
Okay, stop, Ms. Easley Manson. Someone else is talking. Okay, so you got a little work to do between now and September 7th. Ms. Easley Manson, I will see you at most 2 more times if you're thinking about the difficulty of coming down here. You're going to be here on September 7th for your final plea. You haven't been here for that before. So you can roll your eyes all you want, but you need to be here for that. Okay, so that'll be the last chance for the state to say, hey, here's what we're offering, and for you and your lawyer to say, we like that or we don't like it. And then it's real simple. If it doesn't work out that day, you are on our late October trial calendar. And so if the way this needs to be resolved is by having 12 people hear the evidence or lack of evidence so the jury can say not guilty or guilty, we'll do that. But I'm not in the business of just making you come down here for nothing. Like Ms. Feely, I didn't think you were going to need to be here today. We don't get a lot of these motions from the bonding companies. Good. If you got notice, you need to show up. So it was good that you showed up. Keep doing that. What I just told you, though, is that you should only get 2 more notices, one for September 7th for your final plea, and then one for the trial calendar. 2 more. Ms. Feely, anything else?
Not at this time.
All right. Ms. Willingham, anything else on Ms. Easley Manson's case?
Nothing from the state, Your Honor.
Okay. Ms. Easley Manson, my advice is you get out while you can. I'll see you in September. All right. Desiree Holloman. This was a bench warrant situation.
This is another one that I think should be able to resolve today, but I have not gotten a firm offer yet. I don't, it has come through. This is a case also from 2020 that was picked up on a bench warrant and has been in for 32 days.
Okay, who's representing the state on this cruelty to children in the 2nd degree case?
Your Honor, it looks like this is a crimes against children case. I believe that might be Attorney Shapiro. I'm double checking.
Well, now it's Mr. Jordan.
True. I'll shoot Mr. Jordan a text, Your Honor.
Okay. Let us know about that. We will certainly handle Ms. Holloman's case today. How about Tanya Jones?
She's mine, Judge. She's in custody and this will resolve today. I do need to speak to her briefly once more.
Okay, and Mr. Peoples, is this your case?
It is, Your Honor.
All right. So it looks like Mr. Williams waived arraignment. We've got Grimes plea, Jackson plea, Horton during the break we're about to take. May let Mr. Horton go. Final plea, Barwick, November trial calendar. All right, so we just need to see what Mr. Jordan's deal is, if he's going to join us or if Mr. Peoples, as the line ADA, will be covering that. And then we've got another plea. It'd be good to knock out a couple of these pleas, and I want to give folks a little bit of a break, but then we've got our 1 o'clock. So why don't we take one plea while we're waiting to hear back from Mr. Jordan to see if he's going to join us. Is there one you're okay? Yeah, position 6.
Oh, that was handled by Art. Okay.
Yeah.
So do we know who the attorney is on the case?
Right, we think it's going to be Mr. Jordan.
Your Honor, I just sent Attorney Jordan a text message. I'm waiting on a response.
Okay, well, we're going to do a plea, give him a little time to do that. Sarge, there should be a Ms. Martin out there. Ms. Martin, she may also go by Ms. Smith. Yes, yes, sir. Are you Ms. Martin?
Yes.
Come grab this. Good luck with everything.
Thank you, sir.
You're welcome. Sorry to make you wait.
Yes.
You too.
Thank you.
You're welcome.
Thank you, sir.
Ms. Vereen, tell me what you've got on the 1 o'clock.
He's actually in custody.
Oh, okay, because that went to Mr. Render. And has Mr. Stokely retained your firm, or you got this through the C3 project? Okay, good. This is an old case that needs to resolve. Have you had any conversations with Mr. Abate, or has Mr. Render?
I spoke with Mr. Abate.
Yeah.
And he did a recommendation.
Okay.
I just about that.
Okay. All right. And then you don't have an offer for Mr. Horton?
No.
Okay.
Your Honor.
Mr. Peoples.
On Holloman, Attorney Jordan just texted me back. He said it's still going to be Attorney Shapiro, so I just sent an email to gets some sort of confirmation or some announcement.
Okay.
You want to do this Grimes?
Whichever, we can do whichever one you want.
We can do Mr. Grimes.
Okay. Is that lunch?
Keep bringing it back.
No, he just dropped it off.
Okay, so the prosecutor's right here. He's gonna have questions for you. If you don't understand something, let me know and speak loudly and clearly right here. Okay.
All right. Ready, Ms. Rivers? This is position 2 from our plea and arraignment calendar, State versus Rashid Grimes. Hello, Mr. Grimes.
How you doing, sir?
I'm okay. I'm Judge McBurney. You are out here because Ms. Wood told me that you are prepared to enter a plea in your case. Is that correct?
Yes, sir.
Great. Mr. Peoples, who you can see on the screen, is going to put you under oath in just a moment and then ask you some questions. Okay. I may have a few questions too.
Okay, I might too.
Good. Well, that was what I was going to add, is that please let me or Ms. Wood know if you've got any questions. Will you do that?
Yes.
Great. Mr. Peoples, when you're ready. You're on mute.
You're on mute.
Will you raise your right hand? You solemnly swear that the testimony you'll give in the proceedings before you today will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You can lower your hand. Will you state your true, correct, and legal name?
Rashid Hakeem Grimes.
Can you spell it for the record?
All right, first name is Rashid. Middle name is Hakeem, and my last name is Grimes.
And are you at this time taking or under the influence of any drugs, medication, or alcohol?
Well, yes, I'm on medication, but I understand what's going on.
Okay, what medications are those?
Mental health medicine.
Okay. Have you taken them today?
Yes.
Has your taking them affected your ability to understand any of the proceedings before you today?
No.
Okay.
I've been taking them for 6 months. I've been locked up for 6 months.
Okay. How old are you?
I'm 44.
And what is the highest level of education that you've completed?
11th grade.
Do you have your GED?
No, I'm gonna work on that because I get a check, Social Security. I'm like, for mental health. So I'm gonna work on it. Okay.
And are you able to read, write, and fully understand the English language?
Yes.
Okay. You understand that you're charged with the following offenses. Count 1, possession of a Schedule II controlled substance, which carries a sentence range of 1 to 3 years, and count 2, public indecency, which is a misdemeanor, which carries a sentence range of 1 day up to 12 months. Do you understand that?
Yes.
Do you understand that if you plead not guilty, do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
Do you understand that if you plead not guilty or remain silent and enter no plea at all, that you may receive a jury trial?
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
You need any more time to speak with your attorney about your case?
No, but what I wanted to, where's he at? Oh, okay. No. Okay, there you go.
I'll ask again, do you need any more time to speak to your attorney about this case?
No.
Okay.
Okay.
Are you satisfied with their services?
Yes, I am.
Counsel, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment, including any with respect to your client's name?
We do.
Mr. Grimes, do you understand that this is a negotiated plea of guilty, which means that the joint recommendation of the state and the defense to the court? Your Honor, this case came from a non-complex, and speaking with Attorney Wood, apparently there was an previous offer made of 1 year probation that the state will honor. And I would include alcohol and drug evaluation and treatment.
Okay. And Ms. Wood knows this because
It was in the discovery from the non-complex. It was a typed up offer.
got it. Okay.
Thank you. Mr. Grimes, do you understand, however, that the court does not have to accept that recommendation, and the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other?
Yes.
You understand that if the court decides to order a sentence that differs from the negotiated plea, that you have the right to withdraw your plea of guilty?
Yes, sir.
You understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in the federal courts?
Yes, sir.
Do you understand that if you're placed on probation of any kind, that you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
You understand that you are not allowed to use nor possess a firearm while on probation?
Oh, yes, I understand. I don't use them anyway, but yeah.
Are you a
Yes.
citizen of the United States?
Yes.
You understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
There are certain rights that you give up by entering a plea of guilty, which include the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront the witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena the witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. You understand all these rights?
Yes.
Has anyone used any force, threats, or promises which has caused you to enter this guilty plea against your will?
No, sir.
Is it a decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, I am guilty.
How do you plead to the charge of count one, possession of a Schedule II controlled substance,
Guilty.
and count two, public indecency?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, sir.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
You understand that unless counsel is substituted or permitted to withdraw, the defense counsel will represent you until either the end of the current term of court or 30 days from today's date, whichever is later.
Yes.
You understand that you have only 12 months from today for a misdemeanor charge and 4 years for felonies to file a habeas corpus petition challenging the voluntariness of this guilty plea.
Yes.
You understand that you have until the last day of the current term of court to file a motion to withdraw your guilty plea.
Yes.
You understand that any of the filings that we've just discussed must be filed by your counsel unless you're representing yourself.
Yes.
Your Honor, if this had proceeded to trial, the state would have expected to prove beyond a reasonable doubt that on February 24th of 2021 at 741 Morosco Drive, MOROSQO Drive in Atlanta in Fulton County, that law enforcement observed Mr. Grimes laying on the ground on the property of Core at Lindbergh Apartments. Mr. Grimes had no pants or underwear on when he was approached by law enforcement. He also had a pipe up to his face. He was instructed by law enforcement to get up. Law enforcement asked Mr. Grimes what he was smoking in the pipe. He stated that it was ice, known to law enforcement otherwise as methamphetamine, and GBI results confirmed that it's methamphetamine less than a gram. Counsel, do you stipulate there's a factual basis for this plea?
We do.
That's all from the state, Your Honor.
Thank you.
Thank you, Mr. Peoples. I have the request to transfer a repeat offender, which lists 6 convictions. Ms. Jackson, I don't know how your data presents itself. Do you have more than 6 felony convictions for Mr. Grimes?
No, Your Honor.
Okay, then I think I've got the info I need on this document. Thank you. Ms. Tucson, actually haven't looked to see if she is on. Yay, Ms. Tucson. Is Mr. Grimes on active probation in Georgia?
That's what I
He
wanted.
is. He is. Would you like the docket number?
Is it the 17 SC or is it a DeKalb case?
And no, it's the 17 SC 155034.
Yep, I've got that on the notice. How much time remains on that?
16 years, 4 months, and 25 days.
Okay. Ms. Wood, it seems like we should deal with that as well. So these things overlap.
Yes, please, Judge.
Okay.
Thank you.
You're welcome. How long so I'm turning to you, Ms. Wood, how long has Mr. Grimes been in custody?
Judge, when he was originally arrested back in 2021, he served 120 days. So from February 24, 2021 to June 23rd, 2021. Currently, he's been in custody since March 3rd, so 166 days.
And you said
Total of 286.
286. Okay. Okay, got it. Mr. Grimes, is there anything you want to add to what we've heard?
Nope.
Where are you going to live when you get out?
1960 over my mother's house.
Your mother's house?
Yes.
Does your mother know you're coming?
Yes.
Okay. Have you lived there before?
Yes.
Does
my dad is going to pick me up from Fulton County.
Who else lives in the house with you and your mom?
Just my stepdad and my mom.
Okay. And they let you stay there for extended periods or just maybe a couple weeks and you get situated?
No, they'll let this time they're gonna let me stay for 3 months.
Okay.
Because I have to get my Social Security check back on.
Got to get those.
I had went to RSAP and I had graduated RSAP, so my check got cut off, my Social Security.
Okay.
Yeah, so we trying to get all that cut back on.
Do you still have all your forms of identification so you can get your benefits?
Yes, I have my ID at the jail.
Okay.
Yeah,
Good.
my driver's license.
Tell me what diagnosis you have had that causes you to get the medication at the jail.
Okay, I'm diagnosed with paranoid schizophrenic.
Okay. Do you remember the names of the medications?
Yes, I'm on 100 milligrams of Effexor, 20 milligrams of Zyprexa, and 50 milligrams of Benadryl.
When you get out, how will you continue to get the medication?
From 10 Park Place. They already came down to see me.
Excellent.
Oh yeah.
Good job at the jail.
Oh yeah, because see that, mental health medicine helps me.
It does.
That helps me stay away from street drugs too.
And that's our goal here, because then if you are taking the medication that the doctors recommend rather than what you get on the streets, we'll be able to avoid situations like this from a couple years ago. I'm glad your family is there for you, Mr. Grimes.
Yes.
Mr. Grimes, I find there's a factual basis for your plea and that your plea was knowing and voluntary. Voluntary means no one's forcing you to enter this plea. Is that true?
No.
No one is forcing you, correct?
No.
You've decided to enter this plea because that's what you want to do.
Yes.
And a knowing plea just means that you've understood things after you've had all your questions answered. Do you have any questions about anything we've discussed?
Yes, one last question. Okay, let me tell you something. See, I originally got locked up for violation of probation, but this old charge came up. Okay, they had revoked 90 days from me and, reinstated me back on probation. So all I need you to do, Judge, is to do your magic and so that I can leave. And I won't have a hold because of what I went to court for today.
Got it. I will do my best to do my magic. Sometimes that wand doesn't go quite far enough. But, let's see. I'm going to look at your probation revocation order to see in your old case to see if it. Oh, that's small. So you got revoked by a mystery judge. Judge DeFore, for not reporting, very
Yes.
recently you did.
Yes.
So that's not this charge. I just want to make sure we don't get you scooped back up again. You got revoked in August of 22.
No,
For this.
yeah.
No, that's DeKalb. This was a DeKalb.
Yeah, that's another one. I'm
DeKalb.
sorry.
You've been a busy young man. Okay. All right. I just want to make sure we're not double counting. We're not. All right. Ms. Wood, do you waive any due process notice rights that Mr. Grimes has in connection with a revocation in the 17 SC case?
We do.
Okay. Mr. Grimes, first this case, I'm going to sentence you to 1 year and 9 months on count one with, well, let me say it the right way. I'm sentencing you to 9 months to serve on count one, followed by 1 year of probation. So it's 1 year and 9 months. Serve 9 months, but you're going to get credit for all the time you've served. You served a little more than 9 months. So 1 year and 9 months on count one, serve 9 months, balance probated, 1 year probation. Count two, 9 months to serve, concurrent with count one. So the net result of all that is 1 year of probation, which is what you negotiated before when you had a different lawyer.
Okay. Thanks.
Special condition of probation is that you submit to drug and alcohol screens. So we make sure that RSAT is sticking.
Okay.
Okay. And I'm going to ask, I can't tell them, but I'm going to ask that the Department of Community Supervision assign you a probation officer who specializes in working with folks who are handling mental illness like you are. Just so they'll be attuned to the medication you're taking. They're going to know all about 10 Park Place.
Okay.
And hopefully that's what the Department of Community Supervision will do.
Okay.
That's your sentence in this case. I'm sentencing you pursuant to the Probation Options Management Act. And in 17 SC 155034, I'm going to revoke 9 months of that probation because of this new conviction, but give you credit for all the time you served and reinstate the balance in that case.
Okay. Which should be time served.
The 9 months is time served, correct?
Okay.
Okay, because you've done more than 9 months.
Yes.
All right, Ms. Wood, may we sign the indictment indicating Mr. Grimes's guilty plea on your behalf?
Yes.
Mr. Peoples?
Yes, Your Honor.
And Mr. Grimes, can we electronically sign for you?
Yes.
Okay, fantastic. Mr.
Thank you.
Peoples, anything else on behalf of the state?
No, Your Honor.
Ms. Wood?
No, Your Honor, thank you.
All right, Ms. Tucson, anything, what do you need to share with Mr. Grimes?
Well, I first want to confirm with you with the dates, because you said 9 months revoked, credit for time served. I'm looking at the Fulton County website. According to the booking number, he was booked March 3rd. So are we using a different date?
No, they're two different, I'm sorry, I spoke over you. They're two different blocks of time. And
Okay.
Ms. Wood is going to give you those blocks of time right now.
And I'll send it to her as well, Judge. February 24th, 2021 to June 23rd, 2021.
Okay, February 24th, 21.
Through June 23rd, 2021.
June 23rd, 2021. Okay.
And then March 3rd, 2023.
Okay. So I'll just put that kind of like in blocks
Perfect. Thank you.
on the verbiage. And then probation on this new one. And so, Mr. Grimes, do you know where Fulton County probation is?
Yes, it's 276.
276, that's correct. Okay, well, just make sure you do report to probation, okay? When you are
Okay.
released from custody, Ms. Wood did send me, and you'll be reporting since you're already on active probation. They may or may not have this new docket, but it will be notated in your file, and the order will be there for your officer. And make sure you call. Do you have your officer's number, by the way?
Yes, I have it back in my cell. Yeah, I got the
and who do
probation
you-
number. Yeah,
who
it's
do you have? Who do you have down as your officer?
Miss Bell.
Miss Bell. Okay, that's who I have here too, and And it's indicating on here as well, she does not have an address for you. I will send her a notification you were in court today, but just make sure you give her a call, okay?
Oh, I'm going right down here when I get out.
Okay, no problem.
Thank you, Ms. Tucson.
No problem.
Okay, that's it.
Okay,
All right,
all right, thank you. Ms.
you're welcome. Good luck to you.
Thank
There
you,
you
Ms.
go.
Williams. Okay.
All right, let's just talk about, I need to make sure everyone gets at least a segment of a lunch break. Because we still got our 1 o'clock. Yikes. Mr. Peoples, I need you to speak briefly with Ms. Vereen from Attorney Render's office about Mr. Horton. I don't expect you to resolve it today. I don't want to keep Mr. Horton here any longer. Ms. Vereen has something on our afternoon calendar, so she's going to stick around. But I would ask that during the break, the brief break we're about to have, you reach out to Ms. Vereen so that you can at least start the discussion. We're not going to resolve Mr. Horton's case today. I think it's a little complicated, but I want you to start that dialogue, okay?
Yes, Your Honor. If it please the court, I just sent my direct work cell. If the court could provide it to her, she could.
Yep. I will do that. I'll get that to her. Ms. Vereen, once you and Mr. Peoples have had that brief conversation, you can let Mr. Horton go. I'm authorizing you to let him go, but he should stick around until you and Mr. Peoples spoke real briefly, okay? Let me just get that number for you.
Thank you, Your Honor.
Okay, when we come back, we can take Mr. Jackson's plea, maybe? No?
I need to speak with him.
Okay, you'll talk with Mr. Jackson. Then we talked about Mr. Horton. Ms. Holloman, what did we learn from Mr. Jordan about whether he is going to cover the Holloman bench warrant situation? Oh, no, Mr. Shapiro.
Right, Your Honor. I don't see a response. Hopefully after, if Attorney Shapiro doesn't respond, then right after I speak to the attorney that's getting ready to call right now, then I'll look into it and I'll stand in to make the announcements for the state.
Fantastic. And then Ms. Jones is still a plea?
Yes, sir.
So we'll do that right after the break. And then we've got our final plea. I'm not going to call out names yet. Do you, Ms. Wood, or do you, Ms. Feely, have any cases that are pleas off this calendar? You do not. Bad draw. Ms. Wood?
I don't, Judge.
Okay. And then Ms. Vereen, I know you want to speak with Mr. Stokely.
Yes, I believe Attorney Renner,
Oh, he just went right back there.
Yes.
Okay. All right. Should he, hold on one second. Who should talk to Mr. Peoples about Mr. Horton? Okay. All right. So why don't you do that? And then I guess you don't need to stick around either. If you and Mr. Horton are leaving, if Mr. Render's going to handle Stokely, you do whatever you do. Okay. All right. Yes, Ms. Willingham.
Judge, and as to, and I know that we're talking about what's going to happen once we come back from break.
Ms. Willingham, maybe you could put that in an email or a text.
That I will be testifying by the time y'all deal with this. But for position 9, after handle it, I know Ms. Woods and I have communicated about it. So I know Mr. Peoples is here, but I need to know who the attorney is on that case.
You're talking about Gustavus Johnson?
Yes, because it was the PD's office was representing him, but it's my understanding he may be seeking outside counsel. So we're kind of now at a standstill on it.
Okay. What's the word on that from you?
He told me that he's hiring Ed Adams. I'll double check. I haven't seen an interview yet, but I have seen Mr. Adams seen him at the jail, but I just haven't seen it.
Okay. Well, Mr. Adams, I think has 2 cases on here. I think he represents Ms. Scott on the murder side of it. I think you represent Ms. Scott on the other piece. So, okay. Why don't we do this? Ms. Rivers, if we take, I don't want to rush folks, but I want to make sure we get through all these calendars. If we come back in 20 minutes, is that enough time? Okay. All right. So let's be back here at 1:15 to start these pleas and whatnot. It may be that Mr. Horton's gone by then. If you clear that after you talk with Mr. Peoples. So Mr. Peoples, if you'd reach out to Ms. Vereen, actually, she's going to call you because I'm giving her your number right now. Okay.
Thank you, Your Honor.
Thanks. Thanks.
Judge, what you said, we got an hour?
I think two hours. Yeah. Go eat those 2 bags of chips, man. 5 minutes each.
You know, those are
Where there's more where that came from.
Friends up north, right? So whenever they come in. Who has Holloman?
Ms. Field. Do you know if Ed Adams will come here this afternoon?
You know, I haven't heard from him. Usually he is, let me send him,
Get it done, get it done.
no, you don't want to be here all night, do you?
We just got all night, right?
Look at, I
2 o'clock, look, then you go to sleep. Yeah,
because all you could think about is when you got to.
5:40. I gotta be here.
5:40. Why not 5:30? Why not? Why 5:40?
Let's break it along.
Yes.
This one. I'm just in that one. Go back there. It's been very interesting experience so far. I think there was like a little bit of sleep, so I got here but that's also part of the trees.
be there for you.
You try to tell them the truth, I'll tell you, man, I'll be back about 7 minutes. Yeah, I appreciate it. How long do you say they work with you?
I'm all right. Tired. How you doing? You look great. That's fine, hopefully. Judge Adams called in the speedy trial today. We're supposed to be why it's so They're trying. He's trying to rise. It's fine. This is all options for the silence. I'm not going to do that. So, hey, how you doing? Yes, sir. How you been?
We have somebody on the calendar, but I want to see if I can get a continuous from you. I just got this case in June. I was on leave half of June and half of July. As you know how it goes.
Yeah, if you want to ask him, I'm not going to do it.
Okay.
Yeah.
I think you're on it. It's
DeMarcus Stokely. Yes, sir.
Yeah, it's the big homicide.
Yeah.
Are you familiar with the discovery and everything? Where was the blood found?
On the airbag, it's on the driver's side.
Airbag, driver's side airbag. I just want to confirm that.
Yes, sir.
Thank you.
Uh-huh.
But this is my first time on final plea. You know how it is on final pleas, TNC?
I mean, I don't think you'll have a real issue, honestly. Anytime.
Okay. There it is. Okay.
Oh, I can't get a break.
Where are we on Hall?
So, do you have a counter to line?
I can't even remember. We're still alive on Hall?
Oh, yeah. I got it. Give it more. So if you can tell me. And what? What? Oh. That's what I mean. It's very tough.
But it's gonna be good for circus.
It is. It is. So, I mean, we can keep on. I'm open to it. But we have to do it. Oh, yeah.
I'm in Whitaker.
Do one thing.
I'm just here to.
I mean, it's not busy. We're doing shit.
How are you?
Well, like, it's long stroke. Close. Yeah.
Oh.
Yeah, how you close. You all right?
Yeah, how are you?
All right.
Yeah. Good. How are you? Appreciate you. Okay.
Yeah, give me back by that.
All right. So you're not closed. I got something for you.
Oh, sorry, yeah. Yeah, man. I'm gonna take one. All right. Come on. We just want to.
Thank you. I just stepped in the courthouse.
Oh, this one. So we have two. Yes. Oh, I was a bit.
How are you? That's awesome. Good. Been okay? I'm here.
That's interesting. No good deed, here we go, no good deed goes unpunished.
Turn it forward.
So this is the actual sheet with the document. So as
I told them that.
Months. And now we
I wish I could say the same thing. So I wish I could say the same thing.
I've been on Zoom. For me.
I feel like I've been here the last 2 days. It's been a lot of court. Wow. There you go. But I mean, I can hear you talk already. the grant. So, but I think she probably will.
Welcome to order, man.
Investigator Mercure.
Yes, sir.
How are you?
I'm good. How are you, sir?
I'm well. You swear or affirm the contents of your affidavit are true and correct to the best of your belief and knowledge?
Yes, sir. I do.
Great. So this is girlfriend's phone,
Yes, sir.
new girlfriend's phone.
Yes, sir.
All right, I read it. It's all good. You just need to sign by the little orange tab.
All right.
And you're good to go.
Thank you.
All right, good luck.
Thank you, Your Honor.
You're welcome.
Thank you. Have a good day.
Hello, Ms. Primovic. How are you? I saw you this morning, but you were heading away from early. I was coming into work and you were wearing some shades, leaving the courthouse, following Ms. Patterson. Yeah. Okay. Where do we want to pick up? Are there things we can, you all are here for, you've been here all a long time. What case are you here for?
We're ready, Judge.
Okay. So we could do that. Is Mr. Render still talking to, he's outside? Okay. Mr. Peoples, did you end up connecting with Ms. Vereen?
I did, Your Honor. We spoke shortly after the court's recess. I informed her that I'll get an offer over. I'm going to reach out to the victim in this case. It looks like Attorney Jordan, as well as the notes also indicate Attorney Charles, when they had the case, had been working towards a resolution. I think it's something that will resolve short of trial.
Good. This had been stuck for a while with the need to get an evaluation of Mr. Horton, who was not in custody, and it just proved logistically complicated to line that up, but that happened, and we are able to move forward now. So I think what I'll do on that case, and I'll talk with Mr. Render when I see him on the Stokely case, is just move Mr. Horton's case, to the trial calendar, but preserve his final plea rights.
Understood, Your Honor.
Okay. Ms. Mignot, good afternoon.
Good afternoon, Your Honor. Good to see you. Hope you
Same.
got some rest last night.
Yeah, there were a few reporters in the courtroom. Ms. McBurrows sent a chat to everyone, but it was meant for you, wanting to talk to you on the phone. Did you get that? And have you had a chance to talk to her?
I see it now, Judge. I just see it. I will speak to her after this calendar, because I can announce to the court the last offer from the state has been rejected. But
Okay.
I think there might be a way where we can resolve it, because I've spoken to Mr. Peoples and I think we might be able to come to something short of a trial.
Okay, well, since we're talking about that right now, why don't we take care of Ms. McBurrows, and then we'll take Ms. Jones's plea. Ms. McBurrows, I'm going to get you on the big screen here. There you are, and your lawyer as well. Great. So let's get on the record with position 10 from our final plea calendar. State versus Ms. McBurrows. Ms. McBurrows is represented by Ms. Mignot, who is here on the call. Co-defendant has already resolved his connection to the case, Mr. Sexian. Mr. Peoples, what is the state's recommendation if Ms. McBurrows were to enter a plea today? It would be to what, and what would the state be recommending?
Your Honor, the state's offer was, the last offer was to plead to the indictment as it is, with a deviation in the time under OCGA 17-10-6.1E. It would have been to a period of 15 served 7. A stay away from the victim and the co-defendant as well, and a weapons forfeiture.
Okay. All right. So Ms. McBurrows, do you understand that if you were to enter a plea today, the state would recommend that I deviate or go below the mandatory minimum for armed robbery, and sentence you to 7 years in custody, followed by 8 years on probation. That's the 15 to serve 7. Do you understand that's the state's recommendation?
Yes, I understand.
Okay. Today, if I were to sentence you to more than what Ms. Mignot asked for on your behalf, you'd be able to withdraw your plea. No questions asked. Ms. Mignot, and I'm making the number up, she might say, hey, you know what, it should be 5 years to serve. If I go along with the state and say 7 is more than 5, and you could say, I'm not interested in doing that, I'd rather go to trial. And you could withdraw your plea. After today, you can still enter a plea, and it may be that the state makes a better offer and you want to pursue that. The difference will be if I sentence you to something more than what Ms. Mignot asks for, that's your sentence. In the same way as if you went to trial and you were found guilty, you don't get to back out of anything if a jury finds you guilty. That's the main thing that'll change after today, is that you cannot withdraw your plea if you're unhappy with the sentence that you get. Do you understand that?
Yes.
Okay. The state's offer today is what you just heard, 15 to serve 7. It might get better, it might get worse. What you don't get to do a month from now is to say, wait a minute, I want that 7 years to serve. I don't want 10 years to serve or 20 years to serve. That's their offer today. You understand that it expires after today?
Yes.
Okay. Understanding those things, Ms. McBurrows, do you want to go forward with a guilty plea, knowing what the state's going to recommend? Or do you want to have your case move on to a trial calendar, which doesn't mean you'll have a trial, because again, as Ms. Mignot was saying, there may be a different negotiation that works the case out, but your next stop will be a trial calendar. So we can either resolve it or have a jury decide the case. Is that where you'd like it to go?
I want to reject the plea.
Okay. That's a different way of saying what I think you were going to say, which is you'd like the case to go to the trial calendar because you're saying no thank you to the plea. Is that correct?
Yes, sir.
Okay. Then that's what we will do. Let me check one thing here. 3-9. There you are, Ms. McBurrows. All right, you are on our September trial calendar. So I will see you towards the end of September, either because Ms. Mignot and you have worked it out with the state or because you're coming on in here ready to go to trial. Ms. Mignot, anything else on behalf of Ms. McBurrows?
Nothing further, Your Honor.
Okay, Mr. Peoples, anything else on behalf of the state?
Nothing further, Your Honor.
All right, Ms. McBurrows, I will see you on or before September 20th, okay?
Okay.
Thank you.
Go ahead and call the office.
Yes, ma'am. Thank you.
All right, bye-bye.
Thank you, Judge. Enjoy your day.
You too. All right, can we bring Ms. Jones out, please?
And Your Honor, if I may, while awaiting Ms. Jones, I have not gotten a response from ADA Shapiro. So I took a look briefly at this case, at the Holloman case, and I'll stand in.
Great, we'll do that right after it, and that should wrap up. Oh, Mr. Jackson, is that still a plea?
It is, I'm looking into, he's got a state court matter as well, but.
Okay.
All
right. Mr. Peoples, are you ready?
Yes, Your Honor.
Okay, this is position 9 on our morning calendar. 21 SC 177916, State versus Tatiana Jones. Good afternoon, Ms. Jones.
Good afternoon.
How are you?
I'm good.
Good. Ms. Wood tells me you're ready to enter a plea in your case. Is that correct? Yes?
Yes, sir.
Okay. Mr. Peoples will put you under oath. Once you're under oath, you're going to be asked a whole bunch of questions, none of which should be a big surprise to you. If you have any questions, will you let me know?
Yes, sir.
Okay, Mr. Peoples.
Thank you, Your Honor. Will you raise your right hand as best you can? You solemnly swear the testimony you're giving the proceedings before you today will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. We state your true, correct, and legal name.
Tatiana Jones.
Can you spell it for the record?
TatyanaJones.
Are you at this time taking or under the influence of any drugs, medication, or alcohol?
No.
Is there any medication that you normally take that you have not been given today?
No.
How old are you?
26.
And what is the highest level of education that you've completed?
High school. Some college.
Okay, so then are you able to read, write, and fully understand the English language?
Yes, sir.
You understand that you're charged with the following offenses. Count 1, possession of a Schedule II controlled substance with a sentence range of 1 to 3 years. Count 2, possession of a firearm by a convicted felon with a sentence range of 1 to 5 years. Count 3, possession of marijuana less than an ounce, which carries a sentence range of 1 day up to 12 months. Count 4, no headlights with a sentence range of 1 day up to 12 months. Count 5, no insurance with a sentence range of 1 day up to 12 months. And count 6, driving while license suspended with a sentence range of 1 day up to 12 months.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
You understand that if you plead not guilty or remain silent and enter no plea at all, that you may receive a jury trial?
Yes.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need any more time to discuss this case with your attorney?
No.
You're satisfied with their services?
Yes.
Counsel, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment, including any with respect to your client's name?
We do.
Do you understand that this is a negotiated plea of guilty, which means that the joint recommendation of the state and the defense to the court would be a sentence of, Your Honor, we would be asking for 3 years probation, alcohol and drug evaluation and treatment, no driving without a license, and I believe, Your Honor, that count the no insurance charge carries a $300 fine, I believe, as well. I understand that count 2, possession of a firearm carries a sentence range of up to 5 years. We'd be asking that that part be suspended. Do you understand that?
Yes.
And I did not discuss this with Attorney Wood, but also a weapons forfeiture. Do you understand that?
Yes.
You understand, however, that the court does not have to accept that recommendation, and the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other.
Yes.
You understand that if the court decides to order a sentence that differs from the negotiated plea, that you have the right to withdraw your plea of guilty?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes.
You understand that if you're placed on probation of any kind, that you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
You understand that you are not allowed to use nor possess a firearm while on probation?
Yes.
Are you a citizen of the United States?
Yes.
You understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty today?
Yes.
There are certain rights that you give up by entering a plea of guilty, which include the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront the witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of the case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal a convicted of these charges after a trial. You understand all these rights?
Yes.
Has anyone used any force, threats, or promises which has caused you to enter this guilty plea against your will?
No.
Is it a decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charge of count 1, possession of a Schedule II controlled substance?
Guilty.
Count 2, possession of a firearm by a convicted felon?
Guilty.
It's not by a convicted felon.
I'm not no felon.
Oh,
Well, not yet.
excuse me.
It's possession of a firearm during commission of a felony.
During the commission, I do apologize.
That's okay. It's just, they're different with different sentencing ranges.
That's true, Your Honor. So I do apologize. So during the commission is actually consecutive. It means that it would run after. Do you understand that time range?
Yes.
So then how do you plead to count 2, possession of a firearm during the commission of a felony?
Guilty.
Count 3, possession of marijuana less than an ounce.
Guilty.
Count 4, no headlights.
Guilty.
Count 5, no insurance.
Guilty.
And count 6, driving while license suspended.
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
You understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
You understand that unless counsel is substituted or permitted to withdraw, the defense counsel will represent you until either the end of the current term of court or 30 days from today's date, whichever is later.
Yes.
You understand that you have only 12 months from today for a misdemeanor charge and 4 years for felonies to file a habeas corpus petition challenging the voluntariness of this guilty plea.
Yes.
You understand that any of the filings that we've just discussed must be filed by your counsel unless you're representing yourself.
Yes.
Your Honor, if this had proceeded to trial, the state would have expected to prove beyond a reasonable doubt that on
November 10th, 2020.
Yes, Your Honor. At a traffic stop in the area of 7220 Roswell Road in Sandy Springs in Fulton County. Law enforcement was observing the flow of traffic at the intersection of Roswell Road and Trowbridge Road when they observed a maroon BMW traveling southbound, failing to dim its headlights and with a defective driver's side headlight. The traffic stop was conducted and before approaching the vehicle, law enforcement conducted a registration inquiry, and the results stated the vehicle didn't have valid insurance on file. They made contact with the driver, Ms. Tatiana Jones, who provided a driver's license. While speaking with Ms. Jones, law enforcement witnessed a clear baggie with multicolored pills and a white powdery substance in the cup holder next to the shifter. They asked Ms. Jones what was in the baggie. She stated it was ibuprofen and handed it to the officers. A driver status inquiry returned that Ms. Jones had had her driving privileges suspended as of November 6th of 2020 for failure to appear. The multicolored pills were NIC tested and results showed positive for ecstasy. A lawful search of the vehicle also revealed a plastic container with raw marijuana under the driver's seat of the vehicle, as well as a handgun, a 9mm handgun. Counsel, do you stipulate there's a factual basis for this plea?
We do.
Thank you. That's all from the state, Your Honor.
Thank you, Mr. Peoples. Ms. Jackson, any criminal history information for Ms. Jones?
The defendant has 9 cycles. The defendant's last arrest was June 22nd, 2023 in Cobb County for a failure to appear. The underlying charges were Schedule 1 controlled substance and possession of a firearm during commission of a felony. That case appeared to be still pending in Cobb County. She appears to have an outstanding hold out of Sopperton, Georgia, for a failure to appear. The date on that warrant was July 1st, 2022. And she does have 2 misdemeanor convictions. This one in 2022 for expired license. One in 2014 out of Warner Robins, Georgia, for theft by shoplifting. Nothing in addition, Your Honor.
Thank you, ma'am. What's going on in Sopperton?
From my understanding, that case was dismissed because the person who gunned it was said it was his gun, not mine.
You were in a car with a gun again?
No, that was way before these cases.
You were not in a car with a gun?
Yes, but that was way before these cases that I'm on now.
Okay.
I wasn't facing no charges or anything. when that
Okay.
happened.
Ms. Wood?
Thank you, Judge. Before I forget, there were a couple of recommendations by the state that we did not discuss, and I just took a look at the statutes. I would ask the court not to impose the fines on the no insurance and the driving with a suspended license. It looks like that's optional from my read of the statutes.
Okay.
I would also ask that the court suspend the probation on the firearm charge, so that it follows after the 3 years probation on count one.
Okay, I heard that from Mr. Peoples. I thought the overall recommendation was 8 years, 3 on probation, and then 5 suspended.
So that's my bad.
Okay.
Judge, I missed that. Otherwise, Miss Jones is 26 years old. She's a high school graduate. She also attended the Art Institute of Atlanta. She has a great deal of family support. 2 family members are here present in court. I've spoken to them multiple times leading up to today. She has been in custody 30 days. So she served some time in Cobb before she came here, but she's been in custody here in Fulton County for 30 days. Judge, she does have the pending case in Cobb. I've spoken with her attorney there. It's been referred to diversion, but she has been advised that with this conviction, it may kick her out of diversion, so she will have to deal with that at some point.
What are the charges because I thought what Ms. Jackson was describing was this case when she said failure to appear. It's very similar. It's drugs and gun again.
Yes, Judge.
Okay.
It is. It's very similar. So yes, she understands and is well aware that she will have to go to Cobb County and deal with that. And
Is there a hold from Cobb?
as of now, there is not one.
Okay.
But I have been in touch with her attorney this morning and they're aware of what's happening here. She was working at Wendy's prior to her arrest. She's hopeful that she can go back to Wendy's and get her job. She does have family, as I said, and she will be living with them in Warner Robins. I've shared her address and contact information with Officer Tucson. Lastly, Judge, Ms. Jones is asking the court to consider sentencing her under drug first offender. I have advised her that it is discretionary, and being that she has a pending case elsewhere, that may not be advisable, but she is requesting the court consider that.
Okay. Ms. Jones, remind me why drug court didn't work out. I don't remember working with you. I know we did for a little bit, but then I saw you were terminated from drug court. What happened?
I didn't feel the need. I needed to go to drug court because I wasn't on drugs.
Okay.
On drugs.
How long were you in drug court before you quit?
Like 3 months.
Okay. So it was sort of a, this isn't the right fit kind of thing. Okay. Were there any consequences for that? I guess you were in there as a diversion. It wasn't that if you had successfully completed drug court, if it made sense for you to do that, that just would have dismissed your charges, but you didn't end up doing drug court. So now we need to work out your charges. Is that remembering correctly? Okay. All right. So tell me what you think is going to be different when you get out, because it sounds like in Cobb, you've gotten pulled over with drugs and gun in a car. You're saying something so pretend was a long time ago, but it sounds like it was drugs and gun in a car. Here we've got, like, this was actually pretty old. This is 2020. So this was a while ago. The Cobb thing's a little more recent.
Yeah, last year.
Yeah. So how are we going to stop this from happening? It's not helping you out a whole lot that it keeps happening.
I'm not gonna do it no more.
Yeah. I'm just supposed to buy that.
Nah, I mean, I don't do drugs. I'm not gonna be caught with drugs.
Okay. What about the gun in the car?
Not gonna have no gun.
You can't. I mean, you did that one.
They were my firearm, so I can't have a firearm no more.
Okay, that's correct. How were you able to just kick the drug habit? You just decided.
I didn't do them.
Oh, well, how are you not gonna have drugs in the car anymore? Whose drugs were they?
I had somebody else in the car.
Okay, it was the passenger's drugs?
Yeah, and they charged me with it because I was driving.
That's usually what happens. So you got to be thoughtful about who your passengers were. Were the passenger someone you invited, or was this like an Uber thing?
Somebody I invited.
Okay. All right. Anything you want to add?
No.
Okay. Well, I find there's a factual basis for your plea. and that your plea is knowing and voluntary. I'm sentencing you pursuant to the Probation Options Management Act, which just impacts what happens if you've got a small violation of probation versus a big one. Ms. Wood, can my staff sign the indictment on your behalf?
Yes, Judge.
Mr. Peoples?
Yes, Your Honor.
Okay. Ms. Jones, is it okay if my staff puts an electronic signature for you indicating your guilty plea?
Yes.
Okay. So I'm going to sentence you on count 1 to 3 years to, how long were you in custody in Cobb?
30 days.
So it's been about 2 months now?
Almost 2 months. Thursday make it 2 months. I've been incarcerated.
Okay. But you got arrested in Cobb because of a bench warrant from here or because of a bench warrant in Cobb?
A bench warrant in Cobb. I never got the paper saying I had to go to court. Same thing with here.
Okay.
Never received it.
I'm going to sentence you on count 1 to 3 years to serve 1 month with the balance probated, and you'll get credit for the time you've been in. Count 2 has to be 5 years, has to be consecutive, but I'll suspend that. And counts 3 through 6 will all be 1 month to serve. They'll run concurrently with count 1. So you're going to be on probation for 2 years and 11 months, and then you'll have a suspended sentence after that. Special condition of probation number 1 is that you submit to a drug and alcohol abuse evaluation. You'll meet with someone who knows a lot better than I do, maybe better than you do, whether there's an issue there. And if they recommend any treatment, that treatment will be part of your probation. But if what you say proves to be the case, that drugs aren't your issue, you just always happen to be driving with drugs and guns, then you can stop driving with those things and you don't need any counseling to do that. You'll also forfeit the firearm that was in the maroon BMW back in November of 2020. And that is it. Mr. Peoples, anything else?
Nothing further, Your Honor.
Ms. Wood?
No, thank you.
Okay. Ms. Tucson, you're going to be living in Warner Robins, is that right? Who is there?
My sister, she back there.
Okay, the other people who've been waving. Okay. And that's a safe place for you to be.
Yes.
Yes. Okay. All right. Ms. Tucson, if you could talk with Ms. Jones about probation.
No problem. Ms. Wood did send me an email. Ms. Jones, 478-321-2575. I can call your sister on that number?
Yes.
And what's her name?
Lakeisha Jones.
Okay, and you will be staying there with her in Warner Robins, Leisure Lake Drive?
Yes.
Okay, I'm gonna give her a call so I can give her reporting instructions. Basically, I'm gonna have you report on August 31st. And give me 1 moment, and I'm going to confirm the address because I need to double check which. Do you know what county that's in?
Houston County.
I'm sorry?
Houston County.
Houston County. Okay, just give me 1 minute to look that up.
Hello, more please. All right.
I'm so sorry. Does it look like it says Houston?
Yes.
It does, doesn't it? Okay.
Georgia, we say
Houston.
Houston.
Yeah, I was like, is that say Houston? I'm sorry. So the address there is 269 Carl Vinson Parkway in Warner Robins, Georgia, 31088. But I will call Miss Lakeisha Jones to confirm that, okay?
Okay.
And report on August 31st, 2023.
Okay.
Okay.
All right, that is it.
And your family has my number if you have any questions.
All right.
All right, thank you, Judge.
You're welcome. All right, let's bring Ms. Holloman out. Hey, Mr. Adams. Good afternoon. You are here on maybe 2 cases today. I think you've got Ms. Scott.
I do.
And Ms. Scott is here. Hey, Ms. Scott. And then you may now be representing a guy named Gustavus Johnson.
Yes, I do.
Okay, he needs to show up. We'll see. He's a little late. Oh, is he in custody? Okay, it lists bond, but that doesn't mean he made the bond, so he may be in custody. Do you know if you've got it? Is that a question for? Do you have a Gustavus Johnson back there? I don't need him right now. I just need to know if he's back there. Okay, great.
Is he actually representing?
He is saying well, we're gonna have Mr. Johnson confirm that. Okay, great. We'll take care of both those in a minute, Mr. Adams. Sure. John Abate has joined us again. All right, Ms. Feely, you ready?
Yes.
Okay, this is 23 SC 186-568 State versus Desiree Holloman. Hello, Ms. Holloman.
Oh, hey, sir. Hey, how are you?
I'm okay. It's okay. Don't worry about it. Ms. Feely, Ms. Holloman was supposed to be in court on May 11th and didn't make it. And so we're going to talk today about what happened and if I should set aside the bench warrant or whatever's going on.
Yes, and for purposes of today, we would waive arraignment and I'll get the paperwork filed.
Okay, great. Thank you. I didn't even think about that.
An interim plea of not guilty. But in terms of the bench warrant, she is 22 years old. She has some eyesight issues as well as a stutter and difficulty reading. And I believe she just did not get notice, but so what we were hoping to work the case out today.
But you didn't have anyone to talk to.
Unfortunately, because this sounds like, and I don't know how much the court wants to know about the facts, but it sounds like Ms. Holloman was attempting to treat the 6-year-old. This case is from 2020 as well.
Okay.
And used an alcohol swab on his ringworm that he had on his arm, and it stung.
Sure.
And he told his uncle that it was a needle, that it stung like a needle.
Okay.
So I think this would never have gone to trial, but I believe the evidence would support her version of this. She did not mean him harm. She was attempting to render aid to him. And she, I believe, told the police that from the start. But in any event, this is a case that she's now been in jail since July 15th this year because of the bench warrant. So if I can get good contact information from her, we are hoping, since we can't work the case out, and I believe that working the case out would have gotten her out of jail, that the court would consider lifting the bench warrant.
Okay. The address that I've got is an apartment on Hogan Road. Do you still live there, Ms. Holloman?
Yes, sir.
What's the apartment number?
7.
Okay. Then we've got a good address. Do you feel like you've got good contact information, Ms. Feely, for Ms. Holloman?
I'm going to speak with her about one other phone number just to make sure, but I should have mentioned her parents do live in the Greenbrier area in that apartment.
Okay. Ms. Holloman, do you have phone numbers that you can give to Ms. Feely, either for you or for maybe your mom or your dad?
No, sir.
Because you don't know them, or your parents don't have phone numbers?
I doesn't know them.
Okay. We'll work on that. So when you get out, you'd go back to apartment 7?
Yes, sir.
Who lives there with you?
My father and my mommy.
Okay. How many kids do you have?
I have 3.
And you are 22. How old are your kids?
9, 8, and 6.
Okay.
We had a similar conversation about her inability to remember the phone numbers. But I'm looking in Odyssey and I'm not unfortunately coming up with.
That's okay. I don't know that my kids know my phone number. I'm not worried about, I just was curious if there's something she could give you now. Okay. Mr. Peoples, anything you want to share on behalf of the state?
Just briefly, Your Honor, I would ask, because of the severity of the allegations in this, and I've only been able to take a cursory look at some of the documents in this file. I would ask that any of the bond conditions remain the same. Stay away from the minor victim. His name is Cameron Tillman. And I would ask for that, Your Honor, because of the severity of these charges. I understand that defense is saying that this case would likely close today. However, just want to put that on the record.
Okay.
Lord Dion Holloman.
I'm looking at the bond order. It doesn't have any conditions to it other than you need to obey the law. So did you find a bond order that said no contact with that child?
I didn't, Your Honor, but it's just reading the report, I would have imagined that there would have been, but if there's not, then.
Got it. Okay. Ms. Feely, I will lift the bench warrant. We'll reinstate the bond. The bond is actually from the CP era, and so it relates to 2 more serious counts that the state didn't bring against Ms. Holloman. But it'll be it's a technically not a legal bond. It was a UJR. Back then, maybe it was, but that's what will stay in place. We'll get a scheduling order out. Hopefully, Mr. Jordan can connect with you soon, and we can see if this can be resolved. Okay. Anything else on behalf of Ms. Holloman?
No.
Ms. Holloman, where are your children staying now? Are they with your parents? Are they somewhere else?
They with their dads.
Their dads. How many dads?
3.
Okay, 1 dad for each kid.
Yes.
Okay. So when you go home, you'll stay with your parents, not with your kids.
Yes, I'll be with my parents.
Okay. All right. Thank you. What will happen next is you'll get out and you'll go home, and then Ms. Feely is going to want to meet with you and talk more about your case. Okay.
Yes, sir.
Okay. Thank you.
You want to talk about
this? Yeah.
Okay.
Just dropping stuff all over the place. Tired. Would you go lie down? There's no place to rest back there. All right. I'm still reading it. I'm still reading it. Don't worry, I forgot. Okay. Do we want to do Mr. Jackson now, or do we want to plow through a little bit of the final plea calendar? Oh, maybe it's Miss. It's Miss Sarfarazi, so I don't know who took it over. I think she needed to talk to him.
Yeah, I'm happy to take it. I think she was handling that one, but I'm happy to stand in.
Well, why don't we, once they figure out what's going on back there. Okay, well, I'm actually trying to figure out, Ms. Nelson, can you check on the availability of Mr. Brown? He represents Mr. Pitts, who is the first guy on our final plea calendar.
Okay, let me double check and see if this didn't have a lead. Okay.
I'm sorry, I couldn't hear what you were saying.
I'm sorry, Judge. I'm gonna double check to make sure he's not on leave. Just one moment.
Okay, thank you. Is Mr. Adams, why don't we do your two cases? So Ms. Scott, if you'd come on up, please, to the podium.
We're waiting on now from the state on that.
Okay, Mr. Abate was just in here, then he was online. Anyone I know where he is?
He's in the hallway, Judge.
He's in the hallway, great. Yeah, if you don't mind, Mr. Adams, thank you. There he is. All right, we're going to handle Ms. Scott's final plea. I don't know that Mr. Francis, I don't see him anywhere. I don't know that we'll probably move Mr. Watson to a trial calendar unless you knew the offer was something that had a legitimate chance of moving the needle. Okay, all right. So let's get this on the record. 21 SC 178032, State versus Ms. Scott. Ms. Scott's represented by Mr. Adams, who is here, and it's the final plea. Ms. Scott is charged with just one count in this larger indictment that has some pretty serious counts in it. Mr. Abate, what is the state's offer if Ms. Scott wanted to resolve her involvement in this larger indictment?
So,
or this isn't that kind of case?
well, I could say the offer would be 20 years to serve, but I can say that with the caveat that my hope is that we can have an opportunity. Ms. Scott's case should probably go to the trial calendar with Mr. Watson's case. That would likely help it move forward in getting her to potentially do a proffer to act as a witness in the case involving Mr. Watson. We have a pretty good idea of what she should say based on a jail recording that she's captured, kind of advising Mr. Watson to do an armed robbery. So I think once we get into the same room and she can listen to that and we can all listen to it together, we could come to a resolution that is much less than the recommended offer.
Okay. Who was in jail for the call? This is Ms. Scott on the outside talking to Mr. Watson on the inside?
She was on the inside and he was on the outside.
Got it. Ms. Scott was in custody, yes, talking to Mr. Watson. Your understanding of this call, encouraging him to do an armed robbery that is the armed robbery that resulted in the murder?
Yes.
Okay, got it. And Ms. Scott and Mr. Watson have what connection? Mother and son, just friend and friend, boyfriend, girlfriend? What's the state's theory?
I believe it's friend and friend.
Okay. All right. Ms. Scott, you don't need to respond to any of that. I'm sure you have a very different perspective on all that. That's why you've got a lawyer. But I had simply asked Mr. Abate what the recommendation is. And it's 20 years to serve. I have to think harder about how you sentence someone to conspiracy to commit armed robbery. But either way, it's a big number. And my guess is right now, that's not anything you're interested in. So what I plan to do, unless you're going to correct me and say, no, I want to plead today, is move your case and Mr. Watson's to the trial calendar. That doesn't mean you're going to trial, but it does mean that the next time I see you, either you've worked it out or you are going to trial, which you're free to do. You can go to trial if you want to be going to trial with Mr. Watson for murder, armed robbery, et cetera. Your piece of it is just the conspiracy to commit the armed robbery. But it sounds like you and Mr. Adams need to listen to that phone call. And then it may be that you and Mr. Adams need to sit down with Mr. Abate, and you can explain why that phone call has the words in it that are leading the prosecutor to say, it sure sounds like Ms. Scott is counseling or advising or urging Mr. Watson to go do the things that ultimately resulted in someone's murder. But that's a discussion for you and Mr. Adams to have. It's an old case. You keep coming here. You've clearly got other things going on in your life. You're working, and you're going to keep coming here till we resolve it. And I'd love for that to stop. And Mr. Watson, of course, has been sitting in jail waiting for a trial, and he's entitled to that. Right now, you guys are co-defendants, and so you'd be tried together if you go to trial. So I will do what Mr. Abate suggested, which is move your case to the trial calendar. Let me see if I can be more specific. Let's see. 1, 7, 8, 3, 2. Here you are. I don't have a trial calendar date. Ms. Nelson, do you have a sense of what trial calendar this might fall on?
October. Go to November.
November? Okay. You want everything on October. Ms. Scott, I'm happy to answer a question. You should tell Mr. Adams what the question is first, because he may say, no, you and I will talk about that. Did you already talk to him?
Yes, she is advising me she's pregnant and expecting in October.
October the 24th.
Really? That's soon. Okay. First kid, third kid, where are you in the list? Sixth kid. Okay. Boy or girl, do you know?
Girl.
Girl. Well, congratulations. So that would make a November trial kind of complicated. Unless if it were mid-November, I know you can't tell, assuming it's a healthy birth and it goes well for you and your new daughter, then you ought to be able to come to court some in November. Yes or no? I don't know.
I guess yes.
Okay, I'm not asking whether you want to. I'm sure your answer is, hey, I'd rather be somewhere else than in court. But I certainly would never make you come to court if you're supposed to be in a hospital or something. But if your baby girl has been out and about for about a month, then it does seem like maybe you could come to court. But I guess we'll need to see how that evolves, because it won't ever be something that compromises your health or your baby's health. So you said the due date is October 24th. Okay. Have your previous 5 been pretty much on time or early or?
On time.
On time. Okay. All right. Well, if for some reason that November date proves to be medically complicated, we can do December. But this isn't going to go away. It's going to be hanging over your head. And boy, I'd want some closure if I've got a new one coming along to know which way I'm going. So that may be a reason well before you need to take a time out for childbirth to get with Mr. Adams and the prosecutor and say, hey, why am I here? And what can I do to help myself? Because that's really who you ought to be thinking about, and not anyone else in this case, because no one else is expecting a little girl right now. So you and Mr. Adams talk about that. But am I correct, Ms. Scott, that you're not interested in entering a plea right now to a recommendation of 20 years?
That's correct.
Okay. Then we've handled the final plea. We'll move your case and Mr. Watson's to a trial calendar, maybe November. If not, it'll be December. And we'll just be checking in through Mr. Adams as to your health availability for that November calendar. We'll probably put it on there, but I'll take it right off if there's a doctor's letter saying, nope, look, Ms. Scott just had this situation, and either the child is vulnerable or you're in a situation where coming to court wouldn't be healthy. Okay?
Yes, sir.
Do you have any questions for me about process?
No, sir.
Okay, Mr. Adams, I think you may be going away for a little bit, but soon, please do reach out to Mr. Abate to see if the three of you can sort out something so that Ms. Scott is not in the defendant category anymore.
And I think she has another case.
She does the next one.
Oh, right, I forgot. So stay where you are, Ms. Scott. We also have a stolen property case. Ms. Wood, what's going on with that one?
Judge, we are pretty much in a holding pattern, just waiting to see what happens with the more serious case.
Okay,
I do expect a global resolution at some point.
okay. What was allegedly stolen?
Judge, 1 moment. A vehicle, Judge.
Willie Robinson's Dodge Journey. Okay. All right. We'll have that follow right along. The more serious set of allegations is in connection with Mr. Watson's murder. So we'll see how Mr. Adams and Mr. Abate navigate that. But you're right. So Ms. Scott, I don't know how this will all play out. Presumably the stolen Dodge has nothing to do with Mr. Watson. So you're going to need to work that one out with Ms. Wood's assistance, all on, I mean, that's independent of the Watson situation, but I forgot there's that second moving part. So, okay, but we'll move that to a trial calendar as well, because you could say, great, I'll resolve that one, but the state is still saying, well, right now, 20 years for the armed robbery conspiracy. So we'll move this to trial as well. Okay, thank you.
Yeah.
Mr. Adams, Mr. Johnson's case was on for final plea. You are new to the case, but that's not going to slow down the progress of the case. Should we bring, at a minimum, I want to bring him out so he can confirm you're the lawyer. And then we'll have Ms. Willingham let us know what that offer is, and we'll see what we're going to do with it, okay?
Okay, thank you.
Let me make sure we still have a Ms. Willingham. We don't. Do you have that information, Mr. Peoples?
I believe I do, Your Honor. I'm checking my email right now.
Okay. Ms. Vereen, Mr. Render went back there. I never saw him again. Are you going to handle Stokely for today?
It's going to ask for a one-time continuance.
Okay, that's probably not going to happen, but we'll talk about it.
Okay.
Once Mr. Abate's back.
Okay.
That's for position number 9, Your Honor.
Right now, we're doing position 9. Yeah. Gustavus Johnson.
Yes, I have the information for it.
Great. Hey, Mr. Johnson. How are you?
All right.
Mr. Johnson, I want to confirm that you are switching lawyers. Ms. Wood had been representing you for a while. She shared with me that she had heard either from you or in the docket or something that you or your family had retained Mr. Adams. Is that correct?
Yes, it's for the new charges. I'm in Rice Street.
Well, so you're going to have 2 different lawyers, one for one case and one for the other?
Yes.
Well, let's see what Mr. Adams has to say about that.
Oh, no, man. Okay.
Yeah, I can represent him both.
Okay, excellent. I don't know, I don't have a CP number for the new charges. I'm just looking, pardon me?
I can give it to you.
What's that?
It's 23 CP 219059.
Great, let me look those up. Who is Deborah Johnson to you, Mr. Johnson?
I was the person I was just getting a ride with.
Okay, just happen to have the same last name?
Yes, sir.
Okay. All right, I'm looking at this one. So the unindicted case, the allegations are all drugs and having a gun. The indicted case is the one with the more serious charges. But Mr. Adams, what you're telling me is that you will be representing Mr. Johnson in both the indicted and unindicted case.
What's the indictment number?
The indicted case, 23 SC 186-651.
All right, let me give it Ms. Willingham and see what we can do.
Okay, so what I'm going to do is move Mr. Johnson's case to the trial calendar, but I'll preserve his final plea rights because we really can't do that today. You need a chance to learn a little bit more about the case and talk with Ms. Willingham, but I want to make sure it keeps moving forward. And then if you would please file an entry of appearance in the indicted case at a minimum. You may want to also, excuse me, in the unindicted case, but the one that I'm keyed in on is the indicted case. Okay.
And do you have a trial date?
Let me look. It's on the September 20th trial calendar. So about a month away, a little bit more.
Okay, thank you.
So just to recap, you'll file an entry and then you and Ms. Willingham will talk about maybe working everything out.
Okay, thank you.
Great. Thank you, Mr. Adams. I said, thank you.
Thank you.
All right, enjoy your trip.
Okay.
All right, Mr. Peoples, just for your records, position 1, Mr. Pitts, his lawyer's on leave. I'm moving the case to the trial calendar, but preserving final plea rights. And
I thought it was on for an inquiry to see if he completed his diversion.
okay, I have it listed as, you're right, it says final plea, but then it's this inquiry. Is he in custody or not?
I don't believe he's in custody, Your Honor. Last I looked, and then I also had reached out to Ms. Henry from Adult Diversion to see if he had completed it so I could at least make an announcement. I hadn't gotten anything, but if he has, then I'll submit any appropriate orders before that date.
Huh, look at that. So it's both final plea because we want to move this forward. But it was also to check on whether he's completed. So I'm going to do what I said, which is move it to a trial calendar. This is an ancient case and it needs to be resolved. Strangely, it's also on judicial hold. Ms. Nelson, what's going on with Mr. Pitts?
Sorry, Judge, I had it on mute. Let me look right quick. I think it was on the diversion.
It was on judicial hold because he was doing PTI.
Right.
Okay, got it. Mr. Peoples, do you typically find the diversion people to be non-responsive? How long ago did you email?
I reached out again this morning. I reached out last week, but I reached out again this morning. I know that she's inundated with a lot of requests, so it probably got lost in the shuffle. I'll reach out again, but she's normally pretty responsive.
This then would be the third time you've reached out to try to get an answer?
There is a, Judge, can you hear me?
Just barely, but yes.
I'm sorry, there is a diversion order. I'll send it to you. There's one in the system.
Diversion order as in what put him into diversion?
Yes.
Right. We're trying to figure out if he has completed diversion.
Right, and I don't have anything that indicates that.
No. Well, that I assume would be an intra-office thing for Mr. Peoples, just getting word from his colleague.
Right.
All right, well, I'm moving it to the trial calendar. I'll preserve his final plea rights. If you find out ever from this person, Mr. Peoples, that he completed it, then you're right. You can file the appropriate paperwork. We'll see what happens.
Thank you, Your Honor.
Okay. Let's talk about Mr. Stokely. Ms. Vereen, should we bring Mr. Stokely out?
We spoke with him, we did get a case like a month ago.
Okay, and again, you got it because this was one of the unassigned and through the county C3 program, and Mr. Render had said, look, my firm is willing to do that. So you, as in the Render firm, are relatively new to the case.
Yes.
Okay.
We have the recommendation after discovery, just need just a little more time to just speak with them.
Okay. My recollection is that this is one of the older jail cases that I have. Let me see what it's saying about him. Not quite 1,000 days in jail yet, but serious charges. My thought would be that we move it to a trial calendar, but we preserve his final plea rights.
Okay.
So that if you all do come close to negotiating something, but there's a little gap, he can still try a plea, and if I go well past what you are recommending, he could withdraw that plea. But then we'd have a trial ready to go for that. Does that work? Okay, because I don't think anything's going to change from the state side. That this case is old enough that I think the recommendation is whatever the recommendation is. You are certainly entitled to time to get through the discovery and work with Mr. Stokely on that. So I'll have my team move it to a trial calendar. It would be October at the earliest. So it should give you and Mr. Render some time to meet with Mr. Stokely and see if you can get him in the right frame of mind for a plea or if it needs to be a trial. Is that all right?
Sounds good, Judge.
Okay. That's what we'll do then.
That's October.
Yeah, I don't have a specific date. I'll have to talk with Ms. Nelson, but what I'm telling you is it won't be before October. We do have this September 20th one, which is about a month out. I'll make it at least one after that. So you all have a little more time to work with Mr. Stokely. I just want to strike the right balance. Through no fault of your own, he's been stuck in jail with effectively no representation for a couple of years now almost. So trying to get there. Mr. Abate, is this one that if it's not worked out is we need a special setting or anything? We don't do a lot of the homicide by vehicles.
I don't believe it would need to be special set, Your Honor. It can be on the trial calendar and work its way through.
Okay.
Of course.
All
I
right.
don't have any out-of-state witnesses at this time that would require that, but thank you for asking that.
Sure. All right. Do you want me to tell Mr. Stokely that right at the doorway? Okay. Hey, Mr. Stokely. How you doing? Good. I was just talking with your lawyer, one of your lawyers, Ms. Vereen, and explaining to her after she and Mr. Render talked with you that we're going to move your case to a trial calendar in either October or November so that your lawyers have enough time to spend with you and discovery and get prepared. That doesn't mean it has to be a trial. It may be that something gets worked out, but your lawyers wanted some time to get familiar with the discovery. There are a lot of moving parts based on the allegations against you. So I had you brought over today just in case something had worked out. But both Mr. Render and Ms. Vereen asked for a little more time, mostly to spend with you, but also to work through the discovery. So I will see you next, either because something's been worked out or because it's trial time. And that'll be, like I said, either in mid-October or early November. Okay?
All right, so what they mean, so I'll be going to trial, or they'll be coming to me talking about something before they go to trial?
First, that second thing you said, that they're going to come talk to you before, you're not going to just suddenly show up and go to trial. Your lawyers need more time to talk with you and to look at the discovery so they can say, hey, man, you're on video going the wrong way on I-75, 90 miles an hour. You need to work this out. I'm making that up. I don't know what the facts are. But if that's what it shows, look, here's all this camera, and here you're driving and you're waving at the camera and you smash and you kill a baby, they're going to tell you, you do not want to go in front of a jury.
Yeah.
If it's something different, they're going to say, maybe we should go to trial. But what's next is conversations with you and your lawyer. You just, for a long time, you didn't have a lawyer. Not your fault. It's the system's fault. But we were able to line up. I didn't realize we'd get two for the price of one. But Mr. Render and Ms. Vereen. So they're going to be spending time with you. If for whatever reason, you and your lawyers can't work something out with the state, then the fallback is to get you a trial.
Okay.
Does that make sense?
Yeah, it makes sense.
Thank you for asking. All right, I'll see you soon. Should we do Mr. Hall real quickly? I mean, if he's here, I'm assuming the offer's life. No?
Oh, yes, Your Honor, I'm sorry. I got Judge Adams in my ear too.
Oh, do you need to be there?
It's a Zoom encounter. But life is the offer.
Okay. All right. If we could bring Mr. Hall next, please. So we're almost done. There are a whole bunch of folks on the Zoom. We know what they're on for?
They're family members of the victim in this house.
Okay, great. All right, this is position 8, 22 SC 184215, State versus Jason Hall. Mr. Hall is here with Ms. Feely. Ms. Feely had filed an immunity motion on behalf of Mr. Hall. We had that hearing. I've ruled on that, denying the immunity motion. So today is the final plea. I need to make sure that Ms. Feely has all the discovery to which she thinks she's entitled and isn't aware of anything that's missing. How are you doing with that?
Other than wishing there was more of that video, I believe I have everything that the state.
Okay. Mr. Abate, how are we doing on ballistics?
I'm pretty certain that I turned them over.
Okay. I wasn't suggesting you didn't turn it over. It was more, do you have ballistics results?
We got results, yes, Your Honor.
Okay, great. So Ms. Feely, as far as you feel, it's trial ready?
Yes.
Okay. Mr. Hall, the other part of the conversation I have during final plea is usually, hey, you've got the state's best offer right now. Are you interested in pursuing it? Given your charges, Mr. Abate has told me the state's offer is you could plead to the indictment, which means the offer is life. I'm assuming that's not what you're interested in pleading to at this time.
No, sir.
Okay. Then what I'm going to do is make sure that you get on the next available trial calendar, which you may already have been slotted for one. Let me look. Nope. So it'll likely be the October or the November trial calendar because September has already been drafted and it doesn't look like you're in that. So October or November, you'll be here for trial. If for some reason you all work something out, we can take a plea at any time, as long as we've given the victim's family notice so that if they want to be present, they can be present. But that's easy to schedule. Otherwise, Ms. Feely will let you know what that trial date is. And I am mindful that you remain in custody, and so there's no reason to delay this, your day in court. So that'll be the next step. Mr. Abate, anything else on behalf of the state?
No, Your Honor.
Okay, Ms. Feely, anything else on behalf of Mr. Hall?
No, Your Honor.
Okay, Mr. Hall, we'll see you later this year.
Thank you.
So what I've got left is maybe a plea with Mr. Jackson. That's Ms. Feely, I think. And Reginald Hughes.
Also disputed.
Yeah. And I'm assuming he's in custody.
And Your Honor, as it relates to Mr. Hughes, Attorney Feely alerted me this morning, Mr. Hughes has a pending CP case. I believe it's a drug case. Let me double check.
What did I miss? So we've got Mr. Hughes and Mr. Jackson. I think that's all that's left. Jackson is a plea, and then Mr. Peoples was just telling me something about Mr. Hughes and a CP case.
Yeah, so I have offered to waive, actually, I think it's an accusable case anyway, the CP case, because we want to wrap these up. But unfortunately, I haven't been able to do that today. The CP case is what's holding them in.
Okay. So you and Ms. Willingham had pretty much resolved the indicted case?
Yeah, that's going to be me, Your Honor. I think it says Ms. Willingham, but I think it'll be me. Attorney Feely and I were emailing back and forth when she.
More importantly, then you and Mr. Peoples had pretty much resolved the indicted case. Yes. And then any reason we shouldn't take the plea then to that if the CP case, should it be accused, I'm happy they can green sheet it to me, et cetera. And it would just be hey, your sentence can't be any more than whatever it is here.
That's fine. I would need to talk with Mr. Hughes because that wasn't our initial plan. But yes, I think we can get that done today, and maybe the other case will be declined.
Another approach, if it's a more of a possession thing, why don't we do this? I have 2 warrants that won't take long to read and sign. Why don't I do that while you talk with Mr. Hughes to see if he's inclined to do that? It's not a pressure thing, but just I think it would be efficient. And if he wants to, we could take the Hughes plea, and then we can definitely take the Jackson plea. Does that work? Okay. Is there anyone else back there?
Position 2 and 6.
So I can say hi to Mr. Watson. I think his lawyer's on leave. He's going to the trial calendar.
I'll just take it down.
Okay. And 6, he goes to trial a week from this coming Monday.
Okay.
He's specially set. You can tell him that. August 28th, he's going to trial. But I'm happy to tell him that too, if you don't want to be the bearer of those exciting words. No? Okay.
And Jackson's
a plea.
Okay.
So Hughes and Jackson we want to keep, and you can, Watson, I don't know when he'll go to trial, but this Alexander guy, he'll be back here in 2 weeks.
Okay.
He's one of these out-of-state detainer.
Actually, Judge Alexander's going to be brought back over tomorrow because he's on the trial calendar, and Mr. Reeves should be back from leave then, I do believe.
Oh, I thought his leave was tomorrow, Mr. Reeves.
Oh, okay. So if we don't need Alexander, I can not bring him.
Yeah, let's not bring him over. Just, I mean, it'll save the sheriff a person to bring, and he may start getting ornery if we just randomly bringing him over. But if I'm wrong, if you've heard from Mr. Reeves that he's going to be here tomorrow, better that he spend a moment with his client saying, "You sure you're ready to go to trial on this rape?" Okay. So Ms. Feely, if you'll talk with Mr. Hughes, Deputy Gordon can talk with those two gentlemen and let them know they've got trials coming up. I'll read these two warrants, and then we can take for sure Jackson and hopefully Hughes, please.
Sorry, Judge, she was yelling my name.
You did the right thing. I was not yelling your name. I don't think I ever have. I think you're done. You're welcome to stay, but I'm gonna read these two affidavits in the jury room, take care of your guys. And then we've got a couple pleas, but I think they're with Mr. Peoples.
Thank you, Judge. Hopefully those are the last pleas for the day.
They're easy enough. Although this one is thick. What is this, Horton? Why is this one so thick?
There's two.
I think it's two. You're right.
Oh, it's two.
Yeah, two sets.
Yes, sir. I'm not done. I'm gonna sit out here.
All right, don't get, all right.
All right, I'm gonna go read. You guys sit tight. I'm gonna read them, and then I can just swear you.
If juveniles don't mention in this scenario, why are you expecting perhaps caretaker? Very fun. Fine, you'll have. Okay. With signs of abuse. It's different. And you're not investigation. And the but then you gotta find the first. And watch someone, you're gonna press them before finding them. Cheers. Career. Last year.
I was there, I heard it was coming. Well, she went up.
I don't know, I thought I heard it. That's why I said I want to take the box. I don't know.
About on females now.
I know.
They're about on females now.
It's with the service.
I called down there, they don't want to come get it. No, wait. Wait.
They're just hanging in there. Yeah. I said, yeah, so we here. I said, just tired. I'm here right now. Give me 1 minute. You don't have somebody that.
I know, people are taking on. Yeah, we are there now. Amazing.
What all do you have to, that's one question? Can I see it? Yes. Wait, what is this one? Is that Krista? That's Krista. Wait, is he here? I gotta see. Oh, yeah, is he here? Yeah, I wasn't Chris.
Well, I was responding like that. Ain't here as long as.
Oh, wait.
Ain't here early as you were, as long as late as you are. Especially him.
I don't even know seeing him.
One day he was gone.
Yeah.
And he come on weekend.
Oh. Yeah. So like regular.
Next question. He said, well, hey, I sent somebody. He said, I sent somebody.
So we have none.
That should take place, right?
All the things.
They just told us the same thing, 6.
Right.
Okay, they took, I had back until. I know now 7, 7. Okay.
Like 13.
That's in Lakewood, jump everything.
7:30. It might have around the rest of the week.
Oh, that's.
8. 7.
Oh, they said, oh, they just told us, right?
So what they did it for 4 months. Special group.
And it's on the text, I gotta try to believe them all. I got so many groups.
Special group.
Okay, so.
Good shot.
It's freezing in here.
So we just like upgraded one. Pick it up.
What about Hughes?
Hughes is just gonna be a power.
Oh, then, yeah.
What we said earlier, we said Thomas Field.
Dude, what were you laughing about?
What's the tall guy name?
That was,
The one that did,
He's
I think
on-
it was Drizzle or something.
That's talking.
Yeah, but 5 years.
on Thunder Williams.
You were like, it's good now, I don't know now.
Wait, what's the offer on this case?
I didn't get one. That was the one they did.
Oh, he's the one that's like, it was like whenever Cobb, but like sitting down the road from.
Yeah.
Shoplifting.
Yeah, you know, the female that came out. Her name's
John.
The short lady?
Oh, with the little flowers.
Oh, they didn't have, the we weren't representing.
Yes.
Yeah, she had long braids.
Yeah.
Yeah.
One of the ones who was like, come in the big girl.
They gonna what?
He gonna put that thing on.
Oh my God, I would die.
That's why y'all right there.
Right.
With carrots. Yeah, carrots.
Are y'all in here tomorrow?
I'm back. This is a fight.
I have some at home that do, but it's like, I don't control when my plans are. What did I do right? I wish I knew.
We'll go in order, man, see.
All right, Berhalter, yours was a lot simpler. It's not like 20 applications here.
He's not on TV.
Yeah, come on up.
He's not on TV.
So what is the plan is to ultimately indict like 19 people? This is gonna be a mess. Because I signed this, I don't get the case.
I'm cool with that.
Yeah, I mean, I know you guys don't do the indictments, but it was just like a giant crowd of people shooting.
Yeah, apparently, Your Honor, from my understanding, after speaking with the homicide detective and the gang unit, they're all part of the same gang. And apparently the deceased had stolen one of the other one's guns, and a fight ensued or
Okay.
something. So they started shooting out amongst each other.
Yeah.
They did the sensible thing.
Right, okay. You swear from the contents of your affidavit are true and correct to the best of your belief and knowledge?
Yes, sir.
I've signed everywhere else. You sign where the little orange sticky is.
Yes, sir.
You're all set. All right, Horton. Small world. I did the bond hearing today for the other shooter in this case. He's been arrested, the rap star.
Right.
Yeah, he was sitting right here for an hour.
I was able to get him in custody a month or so ago.
Okay, he's probably easier to follow me because he's got his whole. He's supposedly, his agent testified in an effort to get him a bond. But the family said, well, there were 3 shooters. Well, here's 2 and 3. A small world.
Right.
All right.
You just back to check.
No, sir. As long as you sign, I sign everywhere else.
I had a feeling you would have an interest in those.
Yeah, like, oh, hey, I recognize this Wells Street address, and in particular, I recognize the name of the decedent. So that's what the 2 thick ones are, and then you are just trying to figure out what's the new number for Chavez. But this isn't the top 5 calls; it's just top 5 callers because they're not T-Mobile. Like you're sending one to Verizon or somewhere else because this was like 6, 9. Like, why wouldn't you go with the top 5?
And he had he's kind of being wily, Your Honor, about that. He's been out there for a while. He's actually wanted for another homicide that occurred in 21.
Okay.
Lennox Road, and he's got Hispanic descent, and a lot of family, and he's being really good about not letting technological leads get out there.
Okay.
So some of those top numbers for him were internet based numbers. And
Okay,
things like that.
that
So
aren't going to
everybody
help you
down
anyway.
there.
Yeah.
Right.
Okay.
But,
Good. Well, do you swear or affirm the contents of your 3 affidavits are true and correct to the best of your belief and knowledge?
I do.
Good. I have signed everywhere I need to. You can do the rest. It sounds like you need to borrow a pen.
Yes, sir, I do. Yeah, Mr.
He had all sorts of family helping him out today. Great.
I sure appreciate you.
You bet. Thank you. All right. Be safe out there, gentlemen. All right. Take care.
Judge, just so you know, she just called in this meeting for Monday, so I just wanted you to be aware.
Oh, she did.
He doesn't want to resolve it, so we've offered 20 to close all 5 of his cases.
Including the YSL piece.
Correct.
But is he not already serving some life sentences?
A life without parole sentence, but I think there's some worry the way it was tried by the ADAs and the CAB that there's a possibility that it could be overturned due to some inadmissible evidence that was admitted during the trial of that case.
Interesting. Well, don't make that same mistake in front of Judge Adams.
Try not to make any mistakes.
Yeah. All right. Well, yep. See you tomorrow. Ms. Feely, what did you learn from Mr. Hughes?
We are just gonna have a final plea hearing today. He does want to, we're not quite where we need to be negotiation wise for his liking, so.
Okay. And if I check he's on the September trial calendar. So we need to get the state to accuse this is his final plea. So I know it's not for the CP case, but we need to make sure that Mr. Peoples or someone can accuse the CP case in time for that. But that's a month out, so hopefully that could happen.
And Your Honor, I think that can be done, especially since we'll be returning to the office soon. So I think it's more likely that that's something that can be done.
Sure. What is if you know, what's your EDR, estimated date of return to the office?
My understanding, I thought it was next week. I'll double check so I don't show up and I'm the only one there, but my understanding was it was next week.
Okay. Last I heard, the indictment has been handed down. So I was thinking maybe people could come back now, but we'll see. Okay. Well, why don't we bring Mr. Hughes out, do his final plea, and then we'll bring Mr. Jackson out and take his plea. All right. Position 7 is State versus Reginald Hughes. Hello, Mr. Hughes.
How's it going, Your Honor?
Okay. Mr. Hughes, Ms. Feely tells me that maybe the two sides are close, not quite close enough. I know you have an unindicted case that you were hoping could get charged so that you could resolve both matters together. Makes a ton of sense. So I've asked Mr. Peoples, who you see on the screen there as the prosecutor, to get that charged. I think it is an accusable case, but even if it's not, Ms. Feely has said you're willing to waive indictment so that those charges can be formalized.
Yes, sir.
But they haven't been formalized yet. So the only case I've got is 23 SC 187106, in which you're charged with a couple counts of aggravated assault and some other offenses. Ms. Feely, do you have all of the discovery that you suspect is out there?
I do.
Okay, so you're ready to go to trial if this needs to go to trial. All right, Mr. Peoples, if Mr. Hughes wanted to resolve this case today, the indicted case, what would the state's recommendation be?
Your Honor, the state's recommendation would have been that Mr. Hughes would plead to counts 1, 2, 6, and 7. The state's offer would be 12 years probation, completion of anger management, and a stay away from the victim. And that was it, Your Honor.
Okay. So a probated term, a longer than usual one, but a probated term.
Correct, Your Honor.
Okay. Mr. Hughes, do you understand what the state would recommend if you entered a plea today?
Yes, sir. Yeah, I do.
The way it would work today, if you decided to go forward with the plea, is that you now know what Mr. Peoples would be recommending. Ms. Feely could argue for less. It would just mean less probation because there's not a prison term to this sentence. If I were to sentence you to anything more than what Ms. Feely asked for, maybe she asked for 5 years probation instead of 12. If I sentence you to 7 years probation, that's more than 5. You could back out if you decided, I'd rather go to trial than take 7 years probation. No questions asked. You just say, no, thank you, if that's the sentence you're going to impose. After today, you can still enter a plea, and Ms. Feely is suggesting you probably are, if there can be more negotiations and you can resolve both cases together. And I'll gladly accept those pleas, but you don't get a back out if the sentence that I impose is more than what Ms. Feely asked for. Does that make sense?
Yes, Your Honor.
The other thing I need to make sure you understand is that this offer of straight probation, albeit 12 years probation, but straight probation is good through today only. So we may reconvene in a month and you say, great, I'm ready to go. I want those years of probation. And Mr. People says, we've looked at this more. And actually now the recommendation is 10 years to serve 2 years. That would be too bad, but that could happen because their offer is good through today. I'm not saying that because I have any reason to think it will get worse, and Ms. Feely can counsel you on that. But I just need you to acknowledge that today's offer is today's only. It may get better, it may get worse. It may stay exactly the same, but you don't control that. Do you agree?
Yes, Your Honor.
Okay. Understanding all those things, Mr. Hughes, is it your preference to move your indicted case to a trial calendar with the notion that it may still be a plea along with the unindicted case, but for now, you'd rather have it be on a trial calendar than enter a plea today. Is that correct?
Yes, Your Honor.
Okay. You will be on the September trial calendar. It's about a month out. So you'll be back here at the latest for that, September 20th. If you and Ms. Feely can sort something out with the state before then, we'll bring you over here. There's no need to wait until then. But that's when I'll be expecting the lawyers to say, we're ready to go. And if you can't work it out, then we'll do a trial.
Okay, thank you, Your Honor.
Any questions?
No, sir.
All right, we'll see you then.
All right. Thank you.
Oh, he left that up there. Okay, no problem. That's it, Sarge, you're done? 3 o'clock quitting time?
No, in the battery.
Oh, okay. I just noticed you were leaving. All right. All right. We are ready when Deputy Gordon comes back for Mr. Jackson. Should be our last order of business on these calendars.
Are you sure you're gonna be credit for time?
So it's not up to the judge, it's up to the sheriff. So. Yes, unless you like it.
No, I ain't gonna.
Ms. Feely, you ready?
Yeah.
Okay. Position 3 from this morning's calendar is State versus Jonathan Jackson. Hello, Mr. Jackson.
How you doing?
I'm all right. How are you?
I'm doing wonderful. What's yourself?
I'm close to wonderful.
All right.
Mr. Jackson, Ms. Feely tells me that you are ready to enter a plea in your case. Is that correct?
Yes, sir.
Okay. And Mr. Peoples, you'll be covering this for Ms. Willingham?
That's correct, Your Honor.
Okay. In a moment, Mr. Jackson, the gentleman you see on the screen there will be putting you under oath. He's the prosecutor. He'll be asking you a bunch of questions about this case and your rights as a criminal defendant. It's important that if you have any questions during this process because something confuses you, not making sense, whatever, that you let Ms. Feely or me know. Will you do that?
Yes, sir.
Okay. Mr. Peoples.
Thank you, Your Honor. Will you raise your right hand to the best of your ability? You solemnly swear the testimony you'll give in the proceedings before you today will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. Will you state your true, correct, and legal name?
Jonathan Jerome Jackson.
Can you spell it for the record?
Spell it.
Yes.
JONATHAN JEROME JACKSON.
Thank you. Are you at this time taking or under the influence of any drugs, medication, or alcohol?
No, sir.
Is there a medication that you normally take that you have not been given today?
No, sir.
How old are you?
41.
And what is the highest level of education that you've completed?
10th.
Do you have your GED?
No, sir.
Are you able to read, write, and fully understand the English language?
Yes, sir.
You understand that you're charged with the following offense, 1 count of aggravated assault?
Yes, sir.
Thank you. Do you understand that it carries a sentence range of 1 to 20 years?
Yes, sir.
You understand that you have the right to plead either guilty or not guilty to this charge?
Yes, sir.
You understand that if you plead not guilty or remain silent and enter no plea at all, that you may receive a jury trial?
Yes, sir.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, sir.
Do you need any more time to discuss this case with your attorney?
No, sir.
Are you satisfied with their services?
Yes, sir.
Counsel, do you waive formal reading of the indictment?
We do.
Do you waive any and all defects in the indictment, including any with respect to your client's name?
We do.
Mr. Jackson, do you understand that this is a negotiated plea of guilty, which means that the joint recommendation of the state and the defense of the court will be a sentence of 5 years, the first 8 months to serve. Special conditions being that you will wear an ankle monitor for the first 6 months of your release, that you'll have no contact with the victim to be named shortly, that you'll stay away from the victim's residence and or their place of employment, that you'll also complete a substance abuse evaluation and follow any recommended treatment, and that you will possess no weapons.
Yes, sir.
You understand, however, that the court does not have to accept that recommendation, and the court can sentence you to the maximum on this charge.
Yes, sir.
You understand that if the court decides to order a sentence that differs from the negotiated plea, that you have the right to withdraw your plea of guilty.
Yes, sir.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal court?
Yes, sir.
Do you understand that if you're placed on probation of any kind, that you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, sir.
You understand that you are not allowed to use nor possess a firearm while on probation?
Yes, sir.
You're a citizen of the United States.
Yes, sir.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, sir.
There are certain rights that you give up by entering a plea of guilty, which include the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront the witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal a convicted of this charge after a trial. You understand all these rights?
Yes, sir.
Has anyone used any force, threats, or promises which has caused you to enter this guilty plea against your will?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, sir.
How do you plead to the charge of aggravated assault?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes, sir.
You understand that you have only a limited right to appeal this guilty plea conviction?
Yes, sir.
You understand that unless counsel is substituted or permitted to withdraw, the defense counsel will represent you until either the end of the current term of court or 30 days from today's date, whichever is later.
Yes, sir.
You understand that you have only 12 months from today for a misdemeanor charge and 4 years for felonies to file a habeas corpus petition challenging the voluntariness of this guilty plea.
Yes, sir.
You understand that any of the filings that we've just discussed must be filed by your counsel unless you're representing yourself.
Yes, sir.
Your Honor, if this had proceeded to trial, the state would have expected to prove beyond a reasonable doubt that on September 2nd of 2022, law enforcement responded to a dispute call at 2011 Plaza Lane Southwest, apartment 318 in Fulton County. Law enforcement, upon arrival, they met and spoke with the victim, Ms. Shundra Hill, Shundra, Hill, common spelling. Ms. Hill advised that Jonathan Jackson, whom she used to live with, climbed through her apartment window. Ms. Hill told him to leave and he refused, and he punched her in the face. Ms. Hill advised law enforcement that Mr. Jackson was still inside her apartment. Law enforcement attempted to make contact with Mr. Jackson. He jumped out of the window. Ms. Hill was able to positively identify him as the person. Law enforcement showed a photo of Mr. Hill's driver's license, and she was able to positively identify Mr. Jackson as the individual who punched her in the face. Counsel, do you stipulate there's a factual basis for this plea?
We do.
That's all from the state, Your Honor.
So a couple questions about that. The indictment says June 23rd, and you gave a different, of 2022, you gave a different date. It's not critical. I just want to make sure we're locking that in.
Double checking, Your Honor. I'm reading the report that was provided by the officers. 1 second. Yep. The affidavit for arrest, Your Honor, says September 2nd, but counsel, do you waive any defects in the date of the indictment?
We do.
And then the other question is, you described it as a punching and the indictment says something about choking. Did both allegedly occur, or you're saying that the basis is the punching?
I think I can clear that up with the court.
Okay.
I think he's reading from the misdemeanor warrants that he's currently booked in on, Mr. Jackson's currently booked in on, and not the June 23rd.
I see it, Your Honor. I do see. So I apologize. Then it will be June 23rd of 2022, law enforcement, and it's a different location as well. Law enforcement responded to 1660 Stanton Road Southwest, apartment B5B. Ms. Chandra Hill, same spelling, stated that her ex-boyfriend had come to her apartment and assaulted her. She stated that she allowed the accused, Mr. Jackson, to come to her apartment to try and keep the peace as he wanted to speak with her. She stated that while he was there, he became upset, thought she had taken a warrant out, and he attacked her. She described that he grabbed her by the throat and held her down on the stairs. She stated that she was able to get away and fled through the back door. She stated that she and the accused used to live together, and he received mail at that address. Counsel, do you stipulate there's a factual basis for this?
We do.
Thank you.
Okay, I feel more oriented now. Let me ask Ms. Jackson, do you have any criminal history information on Mr. Jackson?
Yes, Your Honor. The defendant has 31 cycles. The defendant's last arrest was December the 27th, 2021 in Fulton County for a failure to appear. The defendant does appear to be on probation in DeKalb County for aggravated assault and false imprisonment. That disposition date was October the 21st, 2019, and the term is for 6 years. In addition to that, he has an outstanding hold out of DeKalb County for a probation violation. The date on that warrant is April the 3rd, 2023. He does have prior felony convictions. It's one in 2003 out of Cobb County for possession of controlled substance. It's one in 2002 out of Bartow County for hindering apprehension or punishment of a criminal. And he does have misdemeanor convictions. It's one in 2011 out of Pickens County for simple battery and obstruction of an officer. It's one in 2009 for obstruction of an officer and theft of services. It's an additional one in 2009 out of Cobb County for battery family violence. And he does appear to have a history of failure to appear. There's one in 2021, one in 2017, and one in 2015. Nothing in addition, Your Honor.
Thank you, ma'am. Ms. Tucson, can you confirm, is Mr. Jackson on active probation somewhere?
Yes, Judge, she was correct. He is on active probation, 18 CR 1860 in DeKalb. Probation ends 4 years, 4 months, and 13 days on this case.
Okay, thank you. Mr. Jackson, do you understand that your plea in this case may have an impact on your DeKalb probation? I don't control that. If it was Fulton probation, we could handle a revocation here, but that's a different jurisdiction. So it may be, I'm not saying it will be, but it may be that probation decides, well, we're going to take out a warrant and Mr. Jackson needs to go see a judge in DeKalb County to deal with the consequences of this conviction while you are on probation in DeKalb. If, this is all big if your DeKalb case, that conviction occurred, I'll make sure I get this right, before this incident. In other words, if your DeKalb conviction is newer, this incident is older, you can't get revoked on older conduct, if that makes sense. How long ago did you get sentenced in DeKalb? You don't even need to try to remember. Ms. Tucson, when did Mr. Jackson go on to probation in DeKalb? or Ms. Jackson, either one. And Ms. Jackson, you probably told me the date of the conviction. I just don't remember the
That's
decap.
okay. That's okay, Your Honor. It was on October 21st, 2019.
Okay, perfect. Thank you. So, yes, this could have an impact on your decap probation. You understand that? Okay. Just want to make sure. Ms. Feely.
Thank you, Your Honor. Mr. Jackson is 41 years old. He has 4 children, 2 of whom are grown. When he has his forklift certificate, when he gets out, I think he intends to continue living with his brother and continue working construction. We are asking the court to accept the state's recommendation. He has the misdemeanor, which the court heard the warrants. I've emailed them to get him scheduled. So we are asking the court to accept this so he can go deal with his misdemeanors and hopefully not, but potentially his decap violation of probation.
Well, it sounds like there's a hold from DeKalb. So you'll be going to DeKalb regardless. I don't know what the outcome will be there, but you've got business in state court downstairs, and then you'll go to DeKalb, assuming they choose to enforce the hold that they've got when we resolve this. Do you understand?
Yes, sir.
Okay. All right. Do you have any questions about anything we've discussed or anything you want to share with me?
No, sir. It'll be it.
That'd be it, you said?
That'll be all.
Okay. Ms. Hill was a girlfriend at one point. What was your relation to Ms. Hill?
Yes, at one point was a girlfriend.
Okay. Any kids with Ms. Hill?
No, sir.
Okay. So the 4 kids you have, different women or women?
Yes, sir.
Okay. Ms. Feely, do you authorize my staff to sign the indictment on your behalf?
Yes, sir.
Mr. Peoples?
Yes, Your Honor.
Okay. Mr. Jackson, is it okay if we apply your signature electronically to the indictment indicating your guilty plea?
Yes, sir. No problem.
I find there's a factual basis for your plea. In June of last year, you put your hands on Ms. Hill in a way that was unwelcome and unwarranted and constitutes a felony. I also find that your plea is knowing and voluntary, which just means you've understood everything we talked about, which you told me you did, and that no one's forcing you to enter this plea, but you've decided that it's in your best interest to move forward. Do you agree with that?
Yes, sir.
I'm sentencing you pursuant to the Probation Options Management Act, which just impacts whether you see probation, if you make a mistake while you're on probation, or you see me. If it's something serious, you'll come back and see me. If it's less serious, you'll see probation. I will follow the recommendation and sentence you to 5 years to serve 8 months. You'll get credit for time served, and the balance will be on probation. This ankle monitor, who's paying for the ankle monitor?
That is a great question.
I've not heard of the county paying for ankle monitors that are not related to bond.
And this was Miss Willingham's condition, so I'm not sure if she had any visibility on that. If he is having to be funded by Mr. Jackson, we would ask the court to consider waiving some probation fees.
So certainly do that. It'll be an incentive for him to get back to work. Okay. Mr. Jackson, you'll need, the ankle monitor is going to be complicated. Ms. Tucson, is probation able to facilitate that? Because what I typically would say is ankle monitor upon release, which is easy enough to do whenever the sheriff concludes that enough of the 8 months have been served, then A&A would come to the jail and put it on. I bet Mr. Jackson is going to be somewhere else when the 8 months run, and then he's not going to need to come back here. He will have served 8 months. Does probation ever, not that you would monitor the ankle monitor, but is that part of probation? How would that work?
The only time I had to recently learn that too, the only time probation handles anything with the ankle monitoring is when they're on the SPS caseload. Other than that, whomever gives them the ankle monitors has to be, I guess, supervised by that company, by that program, by that, because probation doesn't have those on hand. It's only a small amount of people with that unit.
Right. So this would be an outside provider and Mr. Jackson would be paying for it. My question was more, I did not ask it well. How can we make sure that he gets one? And so if I have as a special condition of probation that Mr. Jackson is to have an ankle monitor installed at his own expense to be supervised by the private monitor, how is probation going to enforce that? Will they say, come to probation and we'll have A&A ankle monitoring show up, or how would we do that?
Okay. Usually when there's something like that, like sometimes we have to get them to take certain classes, or even like a hair follicle, they have to bring evidence of that.
Yeah.
If that's stipulated in his order, when he goes to intake for his new charges, they will go over that with him, and he will have to show proof that it's being done.
Okay. Then I guess okay, that's how we'll do it. So it'll be a special condition of your probation, Mr. Jackson, that you find a private provider of ankle monitoring services and get an ankle monitor installed. You'll need to have that for 6 months. The purpose of it is to document and ensure that you are staying away from and having no contact with Ms. Hill. That's someone that it seems like maybe you've struggled with, because I thought I was hearing about this case when Mr. Peoples was reading from a warrant as a whole nother arrest you had for having a dust up with Ms. Hill. I'm not taking sides. It may be a complicated relationship, but it's not a relationship anymore. And the purpose of this ankle monitor, which is going to cost you something, is to have, so we can see you're not going anywhere near Ms. Hill. Okay?
Okay.
All right. I will waive your probation supervision fees for the first 6 months so that you are not having to pay for probation and ankle monitor at the same time. Although I will tell you, ankle monitor is a whole lot more expensive than probation. It's going to seem like you're shopping at Walmart when you're doing the probation, and at Whole Foods when you're messing with that ankle monitor. Another special condition of your probation is no contact with Ms. Hill. Don't call her, don't write her, don't text her, no Instagram, any way you might contact her, and don't use an intermediary. If you and Ms. Hill have a friend, don't talk to the friend and say, hey, let Ms. Hill know I'm sorry, or I miss her, or I'm going to break her arm. Anything like that, that Ms. Hill can document. If she shares that with the prosecution, you'll have a hearing, but I promise you I will revoke a big chunk of your probation if it's demonstrated to me that you tried to contact Ms. Hill. Now, that's not meant to be a trap. If Ms. Hill is texting you, don't write back, but you may want to let Ms. Feely know, hey, this lady's texting me. And so it's not meant to be a trap. Ms. Hill texting you is not a violation of your probation. But if she texts you and says, hey, I miss you, and you write back saying, let's go have lunch at McDonald's, and then you go to McDonald's, you violated your probation. Okay?
Gotcha.
Finally, you'll need to submit to a drug and alcohol abuse evaluation. So someone who knows a whole lot about the hallmarks of, is someone using too much alcohol or some illegal substance, is going to get to know you a little bit. If that person recommends any treatment, that treatment is also part of your probation. Okay?
Gotcha.
Any questions about any of that?
No, sir.
Mr. Peoples, anything else?
Nothing further, Your Honor.
Ms. Tucson, do you have any concern about how I've worded that in terms of DCS being able to implement those special conditions?
No, I will make sure to put that on the case note. But the officer usually, like I stated, if there's new charges or an original disposition, whatever is, in the end when it talks about the other conditions, they go over that with the probationer.
Okay.
And anything that is not complied with can result in a violation.
Got it. Okay. Ms. Feely, anything else?
No, you're.
All right, Mr. Jackson, Ms. Tucson, whose voice you've been hearing here, needs to talk to you a little bit about probation because you will be on where are you going to live when you get out?
I'll be saying that 169 Trinity Avenue.
Which is what?
Atlanta, Georgia.
I know, but what's at 169 Trinity?
Oh, my brother stay right there.
Your brother lives there? Okay. So you're going to still be on probation in DeKalb. You'll be on probation in Fulton, but it all is supervised in one place, which will be Fulton, because that address you gave me is in Atlanta, as in Fulton County. So Ms. Tucson's got to give you your reporting instructions, okay? Well, Ms. Tucson, his release dates.
Oh, I'm sorry, Judge.
No, I spoke over you. he's got a little bit more time to serve of the 8 months, and he's got a state court case, and he's got a hold on from DeKalb. So just factor that in when you're dreaming up the reporting instructions.
No problem. And you said 169 Trinity Avenue
Yes.
in Atlanta?
Yes, ma'am.
Okay, so basically your previous address that I have here on file is stating 2011 Plaza Lane in Atlanta, but because you have a violation, they sent your case back to the DeKalb office. You know where the office is in DeKalb?
No, ma'am.
Okay, you could get that before you are released. It is in Conyers. I will read the address to you shortly, but what you'll have to do is report there, because that's where your original probation case was. This address will be on file, the Trinity Avenue, but they will have to transfer you to Atlanta, and then you will report to Atlanta. But as far as right now goes, your case is currently in DeKalb. Does that make sense?
Yes, ma'am.
The address for DeKalb is 981 East Freeway Drive, Conyers, Georgia, 30094. And so when you are released from custody, report there. They will they'll give you a brief intake. They will transfer you back over to Fulton County to be supervised for both cases.
All righty.
You have any questions?
No, ma'am. This address right here, Memorial Drive. This is what I was reporting at right here. The one downtown by Preach. Right. This is what I was reporting at when I was on probation with DeKalb County.
I think you
Right, you're correct. It was there because your address was in Fulton. But like I stated, now that you have a hold in DeKalb County, they sent it back to the original sentencing circuit. So you'll have to go there initially, and then once you get all that taken care of, they will transfer you back to Fulton County.
Okay, I got you.
Okay.
I got you. All righty.
Okay, thank you. And with that, I think we are done. Mr. Peoples, anything else?
Nothing further, Your Honor.
So we've got a lot of pleas tomorrow. Any chance I can issue an executive order that will get you in the building?
We actually will be, at least I know for myself, as well as Attorney Willingham, I know we'll be in the building tomorrow. They were asking who of us had either substantive motions or, extremely important court. So we made sure to alert them that we had.
Okay.
He and I have green light to come in. I'm not sure about everybody else.
Well, I think you and Ms. Willingham will represent the bulk of the pleas that we've got tomorrow. So that'll be good. Excellent. Well, I'll see you guys then. Appreciate it.
And last thing, Your Honor, Ms. Henry from Adult Diversion responded for Mr. Pitts. It says that he is not in compliance. So I'm not sure what the court would like to do, if they want to put Mr. Pitts on another calendar so that I can make the same announcement with Mr. Brown.
Nah, we'll just move him to a trial calendar.
Okay.
Okay. Thank you.
Thank you, Your Honor. Have a good one.
You too. Bye-bye. Thank you, Ms. Jackson and Ms. Tucson.
No problem. Have a good afternoon.